The Senate Committee on Government Affairs will come to order. Mr. Secretary, please call the roll.
Senator Daley.
Here.
Senator Ellison. Senator Krasner. Senator Neal. Senator Orenshaw.
Here.
Senator Rogich.
Thank you, Mr. Secretary. Please let the record reflect we have 6 members present. We do have a quorum. Please mark Senator Neal as absent excused. Good afternoon, everyone. Will surely be a government affairs after hours type of day. We do have 5 items in the agenda, not including public comment. For those of you following along, I just wanted to give you a little bit of an idea of how we intend for the agenda to move forward. We're going to first hear Senate Bill 447, followed by Senate Bill 287, followed by Senate Bill 274, followed by Senate Bill 343, and then lastly, we'll do Senate Bill 78, which I presume will probably be the lengthier of the hearings, and we'll have a more robust conversation. I also intend to provide some lunch, or better said, dinner, to those of you who are here present. Those of you following along, we're going to have some food delivered in appreciation to everybody hanging out with us for a few hours today. With that said, I also want to do a quick disclaimer on Senate Bill 447. In the interest of time, Mr. Andy Donahue will be doing the presentation. I have been working alongside of him on this particular bill, but in the interest of just moving forward, getting the hearing moving, I will not do my originally prepared remarks. With that, I'd like to open up the hearing on Senate Bill 447. Mr. Donahue, whenever you're ready.
Thanks, Sheriff Flores. Great to be before all of you today. Senate Bill 447 is a attempt to streamline Public Works Administration and is most focused on situations when Public Works law is not followed and causes a detriment to someone. This is most dire and can raise the level of legal action when compensation, safety, or the well-being of taxpayers is concerned. Currently, reasonable legal fees can already be recovered under NRS 338 by a contractor, subcontractor, or supplier when a party prevails in a breach of contract dispute. In a breach dispute against an awarding body, the court or arbitrator shall award to the prevailing party the amount that was required to be paid pursuant to NRS 338 and his or her reasonable costs and attorney's fees. That's already a legal requirement. This bill will broaden that standard to include all prevailing parties that successfully bring legal action to enforce public works law. A few scenarios. An individual who is not paid correctly because of an administrative error could bring action, prevail, get all the back pay, and then still be at a detrimental deficit when legal fees need to be paid out of the amount he or she had already earned through an honest day's work. A similar situation could impact a management entity or a contractor when an administrative error violates these laws and action is needed to correct it. As mentioned, under current law, breach of contract action would make the party whole. However, in this more narrow scope of dispute, it would not. This bill would simply allow judges to consider awarding reasonable costs and fees to all prevailing parties when there's a writ action to enforce provisions of 338. To conclude, I'll just provide a timeline of how we would even get to this point, Sheriff Flores. Number one, there would need to be a mistake by an awarding body. The mistake would have to go uncorrected. A court would need to be asked to help correct this mistake by issuing a writ. The court would then have to decide 2 questions. Does the party asking for this correction have legal standing? And should the court order the awarding body to correct the mistake? Both of these questions would have to be answered yes, and each step would need to happen before a judge would have the agency to use the discretion authorized under this act. So there would be no damages, no profits for anyone, just sound public administration and participation. Thank you, Sheriff Flores. If there are any questions, we can take it from there.
Thank you, Mr. Donahue. Members, any questions? Senator Ellison, any questions? I know you were getting your equipment together, and I wanted to make sure I gave you time.
No, I'm fine.
You're good to go? Thank you. Mr. Donahue, thank you, and I appreciate all the work you did behind the scenes, working the committee and having conversations with the members to preempt a lot of the questions ahead of time. With that, I'd like to invite you to sit back in the gallery, and at this time, I'd like to invite those wishing to come forward, wishing to testify in support of Senate Bill 447, Carson City or Las Vegas. If you could please come forward. Seeing none, BPS, do we have anybody wishing to join us over the phone in support of Senate Bill 447?
If you would like to testify in support of Senate Bill 447, please press star 9 now to take your place in the queue. Chair, you have no callers wishing to supply support at this time.
Thank you. BPS, we'll stay on the phone line. Is there anybody wishing to testify in opposition to Senate Bill 447?
If you would like to testify in opposition of Senate Bill 447, please press star 9 now to take your place in the queue. Chair, you have no callers in opposition at this time.
Thank you. Anybody wishing to testify in opposition to Senate Bill 447, Carson City or Las Vegas? Seeing none, thank you. At this time, we'll move to those wishing to testify in the neutral position to Senate Bill 447. If you could please come forward. Seeing none, BPS, anybody wishing to join us in the neutral position for Senate Bill 447?
If you would like to testify in neutral on Senate Bill 447, please press star 9 now to take your place in the queue. Chair, you have no callers neutral at this time.
Thank you. And Mr. Donahue, any closing remarks? Seeing none, thank you. Again, with that, we'll go ahead and close out the hearing on Senate Bill 447. I'd like to next open up the hearing on Senate Bill 287. However, I don't see Mr. Nick V. In the interest of time, we will instead open up the hearing on Senate Bill 274. Senator Daley, whenever you're ready. No. I know James put you up to do that.
Right?
Senator Daley, welcome.
Mr. Chair, members of the committee, Skip Daly representing Senate District 13, here to present Senate Bill 274, which is, came out of the Sunset Subcommittee interim. So SB 274 is a recommendation from the Sunset Subcommittee to the Legislative Commission. SB 274 is a revamp of Senate Bill 210 from 2023. Senate Bill 210 was vetoed by the governor over a requirement that boards and commissions represent the diversity of the state. There was not any mention of the other provisions from SB 210 in the veto message, which is all that you see here in this particular bill. SB 274 covers the other provisions that were included in SB 210. So Section 1 requires boards and commissions with members appointed by the governor to submit a list of qualified people for possible appointment within 60 days after a vacancy occurs. Real quick on that particular section, Section 1. So out of 29 boards and agencies and various things that reviewed this, one of them, the Board of Education put in a fiscal note. So there's a variety of different ways that we could handle that. We could exclude them, but I don't think poor judgment and bad behavior is a reason to exclude them. The governor can just do this by executive order if he wants to. This was only meant to try to help and give the governor the ability to at least have or know who qualified people are, and have the boards and commission do that. But if people are going to try to fund a full-time position off of this, I propose we just delete section 1 and we won't move forward with it. Section 2 provides for the chair of the Legislative Commission to appoint the chair and vice chair of the Sunset Subcommittee of the Legislative Commission. Currently, they just appoint everyone, and then the chair and vice chair is voted out of the committee. It was a recommendation from the previous Sunset Subcommittee, so we're just bringing this back up, that they have the chair of the Legislative Commission appoint the chair and vice chair. Section 3 deletes the requirement for each regulatory body to submit reports related to agency activity pursuant to NRS 622.05 regarding an applicant's criminal history being a disqualifying factor. So currently under the law, people can petition whatever agency they're going to maybe apply for and say, hey, is my criminal history going to be a problem? They have to produce these 2 reports. We're proposing to delete the requirement for those 2 reports. The requirement for people to position and them still be able to do that, it does not eliminate NRS 622.085. So it allows a person to continue to do what they're doing now. They just don't have to produce a report. And then accompanying those reports was a provision for the Sunset Subcommittee to, in addition to reviewing boards and commissions to see if there were changes or amendments, we could review those committees to see if they've had any activity on people petitioning and how many people they may have not allowed to apply based on criminal history. From what I understand, in the past, every time they've done that review, there's no information, 0. So it's really kind of redundant information that the Sunset Subcommittee would do. So section 4 deletes the requirement for the Sunset Subcommittee to review agency history on those petitions. So that's it in a nutshell. If we're going to eliminate and delete subsection 1 because of the fiscal note, which I think the governor has authority to do anyway, it was just designed to help the governor, but I don't want to argue with anybody over their fiscal note. They got to do their thing, so I would just as soon delete section 1. And then we'll keep the rest of the provisions, which are pretty straightforward. Happy to answer any questions.
Thank you, Senator Daly. Members, a reminder, we are deleting section 1, and that avoids the question of the fiscal note. Any questions on section 2? Thank you, members, and I appreciate it. It is a repeat. I think everybody's comfortable with that. Thank you, Senator. If I could have you sit back, and at this time, I'd like to invite those wishing to testify in support of Senate Bill 274 to please come forward, Carson City or Las Vegas. False alarm. I saw somebody getting up, but they were to leave, not to support your bill, Senator. BPS, do we have anybody wishing to testify in support of Senate Bill 274 over the phone?
If you would like to testify in support of Senate Bill 274, please press star 9 now to take your place in the queue. Chair, you have no callers in support at this time.
Thank you. Next, we'll move to those wishing to testify in opposition to Senate Bill 274. If you could please come forward, Carson City or Las Vegas. Seeing none, BPS, do we have anybody wishing to join us over the phone in opposition to Senate Bill 274?
If you would like to testify in opposition of Senate Bill 274, please press star 9 now to take your place in the queue. Chair, you have no callers in opposition at this time.
Thank you. We'll stay on the phone. Anybody wishing to testify in the neutral position to Senate Bill 274?
If you would like to testify neutral on Senate Bill 274, please press star 9 now. Chair, you have no callers neutral at this time.
Thank you. Now we'll go to the neutral position in Carson City. Whoever wishes to go first.
Thank you, Chair Flores. For the record, Jennifer Berthiaume, that's Berthiaume, Government Affairs Manager at the Nevada Association of Counties, or NACO, whose members represent all 17 counties. We understand and support the intent to fill board vacancies in a timely manner. We also acknowledge that the appointments are ultimately up to the discretion of the governor. With the deletion of Section 1, our amendment is no longer relevant, and we do not have concerns. Thank you.
Thank you. Whoever wishes to go next.
Good afternoon, Chair Flores, members of the committee. My name is Caleb Cage. Last name is spelled C-A-G-E. Here representing Eureka County, and we would like to ditto NACO's comments.
Thank you for joining us. Good afternoon. Welcome.
Kent Irvin, Nevada Faculty Alliance. Our interest in Section 1 was because we regularly advocate in front of boards and also have been involved in the nomination process for some boards, so we would have supported the amendment from NACO, but without Section 1 in the bill. We are neutral, although I might say you might fix everything and still facilitate the process of appointments by the governor by changing must to may.
Anybody else wishing to testify in the neutral position? Seeing none. Senator Daley, any closing remarks? None. With that, we'll go ahead and close out the hearing on Senate Bill 274. Next, we'll open up the hearing on Senate Bill 287. Good afternoon. Welcome.
Chair, members of the committee, Nick Vasiliadis for the record on behalf of the Southwestern Regional Council of Carpenters, here to present Senate Bill 287. I'll do a very brief walkthrough of the provisions of the bill, and I'll turn it over to my co-preventers to give you a little bit of context on why it's necessary and a couple examples. Existing law requires a contractor and each subcontractor engaged on a public work to keep or cause to be kept an accurate record showing for each worker name, occupation, gender, ethnicity if voluntarily specified, issuing state or jurisdiction of the driver's license, actual per diem, wages, and benefits. This bill simply expands that requirement to include the total number of hours and overtime hours worked each day, each week by worker, and the address of a worker who has a driver's license or an identification card. Additionally, this bill allows for a joint labor management committee or a Taft-Hartley trust fund to be able to request these records and gain access to these records without violating confidentiality. Fairly small bill with a few changes, but obviously is going to garner a lot of interest. To our co-presenter Boris Greasley to walk you through some context on why this is necessary.
Thank you, Nick. Boris Greasley with the Western States Regional Council of Carpenters, Chair and committee members. I think it's very important to explain what current law is. Current law allows for any person that files or requests a public records request to be able to access certified payroll reports. That information that is already accessible by any public individual includes the worker's name, the classification, where they have a driver's license, their ethnicity, what their pay rate is. A lot of jurisdictions, though, have expanded what they're actually providing. They're actually providing addresses, they're actually providing how much is being paid in overtime, how much is being paid in regular rate. What we're requesting here, asking, is to standardize this information, just to make sure that everyone understands what is supposed to actually be in a certified payroll report. And what we're asking specifically is to have joint labor management committees be the entity that can not only request this information, but be able to receive a little bit more than what the public is already able to receive. Patty is going to explain what a joint labor management committee is, because I know that might be somewhat foreign in the state, and so we wanted to bring Patty, who's an expert in this area.
Hi, good afternoon. Thank you. My name is Patty McCarron. I'm the Director of Operations for the Carpenters Contractors Cooperation Committee, also known as the Quad C. We're a joint labor management committee, and we partner with local, state, and federal law enforcement agencies across the Western region to combat unlawful business practices that harm responsible contractors, workers, and communities. As part of our labor compliance activities, we rely on access to certified payroll records to ensure contractors and subcontractors are engaging in sound behavior by paying their workers correctly. When our team identifies wage violations, such as hour shaving, worker misclassification, or incorrect pay rates, we take swift action. We report these violations to the proper agency and file complaints to ensure that workers receive their rightful wages while holding unscrupulous contractors accountable. Access to these records enables us to contact workers directly at their homes, free from the risk of job site retaliation. House calls, we call them house calls when we contact them at home, are critical. They're a critical part of our case building process as they help ensure establish trust, allowing the workers to speak candidly about their job site experiences. Additionally, we can, when we're meeting them in the safe environment, we can get pay stubs, if they've got contracts, any other key documents that are crucial evidence against the dishonest contractors who are not paying the workers their wages. Lastly, our enforcement efforts as a joint labor management committee have led to tens of millions of dollars in recovered wages for thousands of workers, along with significant penalties and fines imposed on dishonest contractors. The disqualification of contractors from public works projects and criminal charges, including workers' compensation fraud, payroll tax fraud, and grand theft against company owners and supervisors, some of who have served prison time. And through these actions, contractors will modify their business practices to operate in a legal fashion and compete fairly. And that's the goal. We want to level the playing field. So by ensuring compliance with the labor laws, we continue to protect workers, we level the playing field for responsible contractors, and we strengthen our communities. Thank you.
Just Chair and committee members, just wanted to add something really quickly. The whole purpose of having certified payroll records in current statute is to do three very important things, and Patty mentioned it and alluded to it, which is number one, to protect workers' rights. Number two, it's to ensure fair competition, and to also ensure that our tax dollars are being used responsibly. It is very important that when local jurisdictions commit public tax dollars, that those public tax dollars are actually going to the places they're supposed to be going. And that's the whole premise and point of a certified payroll report, that it's already required by state law.
Lastly, Mr. Chair, Nick Vasiliadis for the record. I think one of the chief complaints or concerns that we've heard so far that this might be a tool used for organizing, and we like the record to show that we're more than open to amendment of some type of language to recognize that this in no way, shape, or form could be used for organizing. It is simply to ensure that compliance with state law and public works is being met.
And as a joint labor management cooperation committee, we do not organize. That is out of the question. We do not organize. So we are strictly fighting wage theft and helping the communities and helping responsible contractors. And so we don't organize, because that has been a question that's been brought up.
Is there anything else? I don't know if you, if any one of you wanted to bring up that we also know that we are working on a conceptual amendment that we're considering, correct?
Yes, Mr. Chair, we were waiting to receive language from interested party, and they were unable to get their language in on time. And so we would anticipate that they would make that available to everybody, all interested parties, including you, Mr. Chair, and the committee as well. But we haven't yet seen it, and so not entirely sure what they're proposing quite yet.
Sounds good. So for now, we'll move forward assuming this is just the entirety of the language. We are in the last week. We may not get that in time, and we can always work on that for another session. Members, questions? Senator Ellison, please.
Thank you, Mr. Chairman. 99% of this is already an existing law. So what makes this any different from what's already an existing law?
Through the chair, to Senator Ellison. We currently,
My apologies. If I could have you state your name for the record.
definitely, Boris Gressley, with the Western States Regional Council of Carpenters. So you're absolutely right. Much of what's already being disclosed is stuff that it's already part of current existing statute. Local jurisdictions have taken a step further by also disclosing additional information because the law has been silent on it. So for example, addresses. So for example, overtime, the hours of overtime or the number of hours of regular pay. Local jurisdictions have done that, but it's not every jurisdiction that's doing it. Certain jurisdictions pick to do it, certain jurisdictions choose not to do it. What we're saying is let's standardize it. Let's make sure that there's a minimum of what jurisdictions are supposed to be providing. And so if we already know that it's very valuable information to be presenting, addresses and the overtime information, let's just make sure to add it in existing law.
Follow up, please.
Is an existing law.
So the component that's not currently clear is in regards to addresses and in regards to the overtime disclosure and the pay rate disclosure. If you look at what we're proposing is actually adding those two things. And it's something that certain local jurisdictions are already doing. We just want to make sure that every jurisdiction has that at a minimum.
Senator Krasner? Next, we'll go to Senator Daley.
Thank you, Mr. Chair. A couple of questions, and I've looked at thousands of certified payroll reports. So when you're looking at the new language there in subsection 7, the total number of hours and overtime hours worked each day and each week by the worker, how are you guys envisioning that working? Like I said, I've seen thousands of certified payroll reports. They already have to show how many hours that worker worked, if he had overtime during that day, so each day, and it goes Monday, Tuesday, Wednesday, Thursday, Friday, it adds enough for all 7 days. So you get the total hours at the work, you get the total pay added up and various things. So I'm not sure how you guys are envisioning that to work.
So we think that specific section, number 7, that language, as you've mentioned, is something that local jurisdictions are already providing. And part of the reason why is because local jurisdictions, they'll look at certified payroll reports, the template that the Department of Labor has, and they'll just use that. And the Department of Labor template has an area for you to actually add the total number of hours and the overtime hours worked. What we're saying is since local jurisdictions are already doing it, let's just codify it to make sure that that's what's happening at a minimum. So that way you don't have other jurisdictions deciding, you know what, even though this template has it, we don't technically need to do it because it's not part of law, and so we're just not going to do it. We're just trying to set a minimum here and standardize it so that way it's very clear for every local jurisdiction.
And your
Understood.
name for the record, please.
I'm so sorry, Chair. Boris.
We don't have to do it up here, but nevertheless. Anyway, so I was just trying to be clear on that because I know a worker can be on more than one job in a day. They can be on more than one public work, but you can't really, without getting too jumbled up, report multiple jobs. So sometimes I know it's a matter of, did they go over 40 hours a week? You're looking at this certified payroll. You don't know because they only worked 16 hours on the public job. The private job, we just don't see the hours. So I know some of those issues when you're looking for compliance. I was just trying to figure out how you guys thought that was gonna work. We're still just focusing on, because if you look at the way the section leads in, contractor engaged on a public work, and each subcontractor engaged on a public work shall keep or cause to be kept an accurate record showing for each worker employed in connection with the public work. So they only have to show the hours in connection with that worker on that particular public work. So I was just curious that you guys were understanding it the same way I was kind of looking at it. Thank you. Get another question?
Follow up, please.
Yes, okay, thank you. So I don't know, and I'm just trying to make sure I'm on the same page again. So when you get into 5B, which is otherwise confidential, when you get further down in there, you're adding the address in. And again, I've seen hundreds, thousands of certified payroll reports. Some employers will put the name and the address, although they're not required. And this is in the confidential section, so they're still not going to be required on the normal one that they put in. Some people put it on there anyway. Some public bodies will redact that. Other public bodies will just say, here you go, and it's not that big of a deal. But I do know I've had questions from Federal Highway Administration several years ago where I was trying to get some information from DOT in my other life. And they said, hey, look, this is the only information we give out. They wanted to redact the name, and I finally convinced them not to redact the name. But they said the address, some of this other information that's in there, the driver's license number, et cetera, is not information we're gonna give to you. Some of that personal identifying information, I think, is even a stretch just to this other group that you're trying to get to. Because when I read your language down below is that you can get it, you can get all of it, driver's license number, social security number, and I'm not seeing why you need that information. Address, I get.
Through the chair, Senator Daley, Boris Gressley, with the Western States Regional Council of Carpenters. So yes, so a couple of points. Number one, as you mentioned, Senator, currently any public individual can go submit a certified payroll record, and they can actually, in some cases, in some jurisdiction, receive the address. They can get the address, they can get the full name, they can get all that type of stuff. What we're trying to do here is say, look, let's, again, set a minimum criteria, provide the addresses so that way every local jurisdiction knows, but because of the sensitive information that is at times providing an address, just allow a Joint Labor Management Committee to have that access. A Joint Labor Management Committee, its main focus and purpose is to protect workers and to create a level playing field. And so we're not saying allow the unions to have this, we're not saying allow all public people to have this, we're not saying we're just specifically saying let a specific set of organizations that deals primarily with labor compliance to have this information, to do those house calls, to do those job site visits, to make sure that the worker is getting paid and that the tax dollar that is being spent wisely. We see how much wage theft occurs in public works job sites. There was a report that came out not too long ago in the state that talked about how much wage theft is going on. We are trying to protect workers, and we truly do believe that this information will allow us to get there. Now, as far as specific information such as having the driver's license number, and if that's of concern, we understand, we're willing to amend that and say, hey, we don't need access to a driver's license a person's driver's license number. It's really the address that's very important and the name, because that's how we can actually talk to a worker outside of the job site in a place that's safer for them, because a lot of times workers do not want to talk about what's going on to them in a job site. They want to do this outside of a job site in the comfort of their own home. And that's the reason why we added this. But of course, we're willing to amend if that's the issue about the license number or even the jurisdiction where the license is issued. We're willing to amend that.
Thank you, Mr. Chair. And I understand, and you did answer one of the other questions. It is limited to the Joint Labor Management Committee, not the union. The other question I had is, I've been a trustee on our trust fund, all four of them, for 25-plus years, and we've never once done this type of compliance. If we're the trust fund, in fact, our pension plan, health and welfare plan, vacation plan, they don't even have any employees, right? So we don't do this, so I don't know why you have to have the Taft-Hartley part in there, because they don't do that work. And if we're going after a contractor for something, it's completely unrelated, they have to be signatory, and we have a pretty strong ERISA statute in court process to get the information we need. But when we get it, the trust fund gets it, it's all confidential still as well. It just seemed to me. So final question, if I can, Mr. Chair. Seeing as how this, it does exclude, quote unquote, the union, the actual union, do all of the building trades unions engaged in this have a labor management cooperation trust? I believe the laborers do with Lesset. I know the carpenters have the Quad C. I believe the painters have one. But does every trade have one, or is it going to be only some people are going to have access to this?
Chair Nick Vasiliadis, for the record, through you to Senator Daley. I don't think we could accurately answer that question about all of the other trades, but as you referenced, carpenters do, laborers do, and I'm sure many others do.
Understood. And then we might want to find out what the feds do, because if there's federal money on a lot of CIST, especially on highway jobs, if they have a different rule than this, they may say, hey, look, you're not in compliance, NDOT, with our standards, so it potentially puts some of that funding at jeopardy. We wouldn't want to risk that. I know there's language in there about for preferential bidding and stuff, if any of these provisions would cause any funding to not be available, that it wouldn't apply. So just something to look into. That was it. Thank you, Mr. Chair.
Chair Flores, through the chair, to Senator Daley, Boris Grussley with the Western States Regional Council of Carpenters. From our experience, DOT relies on the template that the Department of Labor has, and the Department of Labor template does actually request a lot of the information that we're trying to do here. So I don't think that it's going to impact any sort of federal dollars, but we would definitely look into it.
Understood, and I only bring it up because it did happen to me once with the laborers in the FHWA, and I was able to get the names, but nothing else.
Members, any additional questions? Seeing none, thank you again for the presentation. I'd like to invite you to sit back, and at this point, I'd like to invite those wishing to testify in support of Senate Bill 287, if you could please come forward. Carson City or Nevada, support for Senate Bill 287. Seeing none, BPS, do we have anybody wishing to join us over the phone? Support for Senate Bill 287.
If you would like to testify in support of Senate Bill 287, please press star 9 now. Chair, you have no callers in support at this time.
Thank you. At this point, we'll invite those wishing to testify in opposition to Senate Bill 287, Carson City or Las Vegas. Good afternoon, good evening, welcome. Whoever wishes to go next.
Thank you, Chair, members of the committee. My name is Mac Bybee. I'm representing the Associated Builders and Contractors. As stated, I think, and would like to reiterate, a lot of this activity is already captured in state law. I myself have actually requested certified payroll, did an audit, and found a contractor in Southern Nevada was splitting categories, which anybody who's familiar with prevailing wage knows that that's not a legitimate way to assign wages to the individuals on this work. I turned that over to the Labor Commissioner, and the Labor Commissioner agreed and brought forth action. The reality is that labor management is not the authority to enforce labor law in this state. It is the authority of the Labor Commissioner. And hearing from some of the individuals that have received these house visits, they can be intimidating and unsettling. They are not. 84% of the construction workforce chooses to work without a union affiliation. If they want to be a part of the union, they could join it, but they don't. And there's reasons for that that each individual has to make for themselves. But allowing this type of intrusive language, I believe, is more harmful to the worker for those workers that choose to work non-union. Thank you.
Thank you for joining us. Good evening. Afternoon, excuse me. What is it, 4? We will get to evening at some point. Yeah, it's still early.
Thank you, Mr. Chairman, members of the committee. Alexis Motorex of the Nevada Chapter Associated General Contractors, representing the commercial construction industry in northern Nevada. And we too are here opposed to AB 287. As it's written, it will require sensitive information about employees to be provided to organizations who have no reason to have it, potentially to be used to harass employers and make jurisdictional claims for work which differs from those of regional practice. Misclassification is already illegal. Not paying prevailing wage is already illegal. Making it more illegal won't make cheaters not cheat. It will just make it more expensive and cumbersome for good contractors to do public works in this state. If contractors are cheating their employees, it should be investigated and subject to the penalties already in statute. We are hoping to give the Labor Commissioner tools to better investigate and enforce violations of NRS 338 and AB 502, and I would encourage you to support that bill when it gets to your House so that we can make sure employees and law-abiding contractors are protected. Thank you.
Thank you for joining us.
Good afternoon, Chair and Committee. Brian Reeder on behalf of the Nevada Contractors Association. Also in opposition, the NCA represents the commercial construction industry in Las Vegas. That includes signatory and open shop contractors, also opposed to SB 278.
And thank you for joining us. Anybody else wishing to come forward in Carson City or Las Vegas? Seeing none, we'll go to the phone line. BPS, do we have anybody wishing to testify in opposition to Senate Bill 287 over the phone?
If you would like to testify in opposition of Senate Bill 287, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 779, we can see your hand is raised. Can you please press star 6 to unmute? Please continue.
My name is Jordan Cranebuell. Last name is Krahenbuhl. I am the Executive Director of the Plumbing, Heating, Cooling Contractors of Nevada. There is absolutely no reason that we should have to provide home addresses and driver's license information. You don't need that information to do what you want to do, and all that does is run the risk of putting the open shops at risk for organizing efforts that is unwanted and unneeded. So we are absolutely opposed to this legislation.
And thank you for joining us. Next caller in opposition, please.
Chair, you have no more callers in opposition at this time.
Sounds good. At this time, we'd like to invite those wishing to testify in the neutral position, either in Carson City or Las Vegas, Senate Bill 287. Seeing none coming forward, BPS, do we have anybody wishing to join us over the phone? Neutral to Senate Bill 287.
If you would like to testify neutral on Senate Bill 287, please press star 9 now. Chair, you have no callers neutral at this time.
Thank you. And any closing remarks we may have? None? Seeing none, at this time, would like to close out the hearing on Senate Bill 287. Thank you for joining us this evening. Next on the agenda is Senate Bill 343. Senator Daley, whenever you're ready. And with that, we'll open up the hearing on Senate Bill 343. Senator Daley, whenever you're ready.
I'll try to make it as simple as I can. Skip Daly for the record, representing Senate District 13. So this bill came from the Sunset Subcommittee as well. So SB 343 was requested by the Sunset Subcommittee of the Legislative Commission. All motions on the recommendations for legislation contained in this bill was voted on and was passed unanimously by the Sunset Subcommittee. So in that, the Sunset Subcommittee voted to terminate 7 advisory boards, councils, or working groups. So of those 7, I have another little cheat sheet here. So we voted to terminate the Advisory Committee on the Rights of Survivors of Sexual Assault. Let me explain just a little bit on that. So this group was started and it came with an appropriation. Actually, it was a grant to try to end the backlog of rape tests, kits that were not tested. That work has been done. The grant of money has been spent. That advisory committee hasn't met for a great number of, a period of time, and their work is completed. So the work, and I don't know if Chief of Staff Benita Thompson is here. I was hoping she would be, but I don't know if she is. Yes, she is, okay. My understanding is that the victim survivors, various things is handled in other areas of the Attorney General's office, and she may be able to answer a question on that. I knew there would be questions on that, on what was going, but that's what I recall of that committee, was to take care of that backlog. They had a grant, the money's been spent, the work's been done, so the committee really doesn't have any work left to do. We voted to terminate the Technological Crime Advisory Board. Similar to that, both of those, this one and the previous one were in the Attorney General's office. So this Technological Crime Advisory Board was an old version of this. The technological crimes, it was basically more on paper type of stuff, and that's how far back we were. So the technology has changed so much. There's, and I believe these were the words of Chief of Staff Benita Thompson, there's a robust program within the Attorney General's office fighting cybercrime now. This board was no longer leaded, and that work is actually being done. If you have any questions, she should be able to answer that for you as well. There was a recommendation to terminate the commission to review the compensation of constitutional officers, legislators, Supreme Court justices, judges of the Court of Appeals, district judges, and elected county officers. That board has not met for 30 years, right? It dates back to 1990, right? They did come out with a very comprehensive report. I read it, they showed it to me. They had recommendations and nothing happened. Since then, we've had several other studies and several other chances. This committee was recommended 2 sunset committees ago to be terminated, and it was held on to the last minute. So I told them I wanted this bill to come to the Senate, that I wanted to present it. I want to emphasize to the committee, this group has not met in 30 years. There is no need for it. And we want to go ahead and terminate it so it's not on the damn books anymore. Don't argue with me, please. We voted to terminate the council to establish academic standards for public schools. If some of the testimony from that, so this committee had a step in the process to establish academic standards. And because the committee couldn't get a quorum, wasn't meeting very often, was very slow to do, they were actually holding up the processes to get academic standards approved. If this board is not there, this work is already being done. Department of Education came in and said, we get it done without them, it actually just holds us up. So by removing this, it will actually speed up the process for academic standards to be approved. We voted to terminate the forever chemical, the PFAS, I'll just shorten it because I don't know how to say those words, substances working group. I spoke with the sponsor of the bill that put that in, which was Assemblyman Howard Watts. The work has been done. We spoke to the firefighters. The work has been done. They gave their recommendations. The federal government has standards in place that the state has to follow for workplace environments regarding the forever chemicals there. So the working group's work is done, and there's no reason for it to continue. We voted to terminate the advisory board on automotive affairs. This is another one that had trouble getting a quorum, really didn't meet. They weren't actually doing anything useful that was helpful to anybody involved. And the trade organizations and associations do most of the work now anyway. This advisory group really had been ineffective for some period of time. And then the seventh one was we voted to terminate the High-Speed Rail Authority. So as you know, the Bright Line project has been awarded. The High-Speed Rail Authority was to help facilitate that selection and the various steps there. There was a provision in the law where if there were bonds issued that the High-Speed Rail Authority Board would have oversight over those bonds. No bonds were ever issued. Bright Line's going forward. It's funded through the federal mechanism. The contractor's been selected. The work is completed. I did talk with several of my counterparts from Southern Nevada with some of the trades down south, and they said the work is done. They don't need it. So those are the seven on the list that we voted to terminate, and we're hoping that this committee will uphold those recommendations. We spent quite a bit of time going through that. So on the list, bear with me here for a second. Okay, so the committee voted to terminate the advisory committee on medical innovation and transfer the duties to other departments within the Department of Health and Human Services. Let me find it on this sheet here. So it was repealed in section 51, and then some of the duties were transferred in section 46 of the bill. I know it's a long deal. The committee recommended to continue the advisory council on graduate medical education with no changes. That's not in the bill, my apologies. Okay. The committee recommended modifications to subsection 6 of Nevada Revised Statutes on 394.644 on post-secondary education. So there are some sections there. Let me find them. I'm sorry, I think we just kept that one. We didn't make any changes. Let me go over my notes here for a minute. Okay, yes, on that, number 13 on post-secondary education, what we did there in section 42, the Commission on Post-Secondary Education eliminates redundant background checks. So there was a provision where people have to get a background check, and then there was a redundant provision. So on the redundant provision, we remove that. If they've already got the background check from a previous agency they've had to go through in order to get that, or they would have to continue through the one, but they wouldn't have to get both. So that's the change there. Section 14, or go to on the, it's actually sections 1 through 5, sections 11 to 14, 20, 21, 44, and 45, regarding the 4-H advisory, the 4-H camp. So in that, they had some technical revisions that they wanted to make. So subsection C6 restates the purpose of the 4-H camp. Subsection 7 revises the 4-H camp board in terms. Section 8 of those deletions were requested by the advisory committee. Section 9 and 10 required legislative approval before the 4-H camp can be sold, traded, or leased for other use. one of the recommendations from the 4-H Camp Advisory Board, besides the name change to the cooperative extension, from the administrative cooperative extension, was there was concern that somebody may try to make a finding that the 4-H camp is no longer meeting its purpose and then try to sell that piece of property on the lake. So the way it is now, you would have to get the okay from the advisory committee for the 4-H camp. You would have to get the okay from the regents, Board of Regents. You would have to get the okay from the governor. And now you would have to get the okay and approval of the legislature before any of that could happen. Just wanted to make sure that that camp is not, it's a very valuable piece of property right there in South Shore. And we want to make sure that it's there available for future generations. And then I believe the last piece was the Rain Land Resource Commission, referred to Section 50. We just wanted to change them so they would have staggered terms. And I'm sorry for jumping around there. I was a little bit jumbled on the whole thing, and now the bill was laid out and it moved around in different sections. But I think I hit all of the changes that we made in the bill. I will do my very best to answer any questions, but I gave the explanation on the ones that we terminated and the reason for that. And if Chief of Staff has any comments or questions I can answer, I'm sure she can.
Perfect. Thank you, Senator Daly. Members, will open it up for questions, and inevitably, you're going to get a question of why you're getting rid of a committee that a board hasn't met in 30-plus years. You know it's coming.
Absolutely.
Senator Ellison, please.
Daly, it's good to see some of the stuff that was in here, but I might be wrong, and I've been wrong before.
Me too.
But I know that the governor's office, what I heard, was working on combining a lot of these different boards, and is this separate from what he's doing?
Kip Daly again for the record. Yes, it's separate. In fact, some of these that are on here were recommended for deletion in his SB 78. We're going to hear a little bit later today. So several of these were recommended on there. The Sunset Subcommittee meets in the interim every 2 years. We try to look over at least a dozen or so. There's no real limit on what we're supposed to do. And we try to review the boards. We reviewed 15 different committees this last time. Several of them we just said, hey, we're going to continue. 7 of them we said terminate. A couple others we said terminate and move their jurisdiction. And then we made amendments to a few. So this is separate from the realignment of boards and commissions.
Thank you.
Members, any additional questions? Seeing none, thank you, Senator Daly, for presenting the bill. At this time, I'd like to invite those wishing to testify in support of Senate Bill 343. If you could please come forward. Good afternoon. Whenever you're ready.
Good afternoon, Chair Flores and members of the committee. My name is Luke Flanagan, Flanagan, with Ferrari Reader Public Affairs, representing the Nevada Association of Career Colleges. NACC is the trade organization representing Nevada's private post-secondary educational institutions, and we are here in support of SB 343. Specifically, Section 42, which provides a limited exemption for faculty and staff of these institutions to submit to fingerprint background checks if they currently hold a Nevada-issued professional or occupational license for which a background check has already been conducted. This change would provide administrative efficiency for both our members as well as the staff of the Commission on Post-Secondary Education. We'd like to thank the Sunset Subcommittee for bringing forward this recommendation and would urge the committee's support. Thank you.
Thank you for joining us. Welcome.
Good afternoon. For the record, Teresa Benitez Thompson, Chief of Staff to Attorney General Ford. First, I have to say I have no idea how that testimony was read off the phone. I've got mine in paper in 16-point font, and I think I still need my glasses to read this. So just quick note, we want to thank the advisory committee for working with us and want to make sure we just have information on the record related to the 2 advisory boards that are proposed, one for elimination, one for consolidation. So first of all, regarding the advisory committee on the rights of survivors and the rights of survivors of sexual assault. So that was established in the 2019 session. The advisory committee had 2 main objectives, both of which at this point we feel have been accomplished. First, to create a document explaining the rights of the survivors pursuant to the Sexual Assault Survivors Bill of Rights and other relevant law, then make the document available to medical providers, law enforcement officials, and prosecutors. Second, to distribute $150,000 in fiscal years 19 and 2020 to award grants of money to organizations to train and recruit advocates for sexual assault. The advisory committee set to work. However, the $150,000 was referred back to the legislature during the 31st special session, and the Office of Attorney General went looking for dollars, found grant dollars, and were able to supplant that funding. So all of the dollars in the end were appropriated. The result of the work can be found in the September 1st, 2020 report to the Legislative Council Bureau, as well as AB 176, Training of Trainers, produced by the Nevada Coalition to End Domestic Violence and Sexual Assault, and the document Sexual Violence Advocacy, produced by the Rape Crisis Center. So now that the advisory committee has completed their 2 main objectives, ongoing monitoring of the work is better accomplished by consolidating the advisory committee into the Committee on Domestic Violence in our Chapter 288. The Committee on Domestic Violence met and voted on this consolidation and moving ongoing functions from the advisory committee into their work. And we actually have a bill on the other side of the House Assembly, Bill 45, that represents that consolidation. So important language and functions are still going to be retained in statute. The Attorney General's Committee on Domestic Violence has membership, had a lot of membership in common with the Advisory Committee on the Rights of Sexual Assault Providers, and same topics as well. Most of the providers, all but one of the community providers in the state, had moved to dual item topic representation of domestic violence and sexual assault. So it really aligns better with how the community and our community providers are responding to this work at this time. Regarding technical crimes, Bill, the Nevada Cyber Crimes Task Force was stood up during Attorney General Del Papa's tenure, and initially it was a multi-agency task force comprised of Las Vegas Metro, the U.S. Postal Service, the FBI, Clark County School Districts, parole and probations. However, the Nevada Cyber Crimes Task Force no longer exists, and since then a singular task force has evolved into subject matter area experts. For example, the FBI's Northern Nevada Child Exploitation and Human Trafficking Task Force. The committee had substantial hurdles obtaining a quorum, so they last met in June 2020. And there's also been a duplicative type of committees stood up. For example, in 2017, the legislature created the Office of Cyber Defense Coordination, which was housed under the Director of the Department of Public Safety. The efforts continue and this work continues. It is well embedded into the thread of the Office of Attorney General. For example, we still participate in the Northern Nevada's Child Exploitation Human Trafficking Task Force. We have grants that come in, including a new grant that we just launched, 2024 local law enforcement grants and enforcement of cyber crimes and solicitation. We also have the AG's high-tech crimes unit, digital forensic analysis. And so we are engaged in this work. We no longer need an advisory task force to direct this work or to coordinate law enforcement agencies. It's happening organically now. So we see absolutely no harm with the sunsetting of that advisory committee.
Thank you again for joining us. Please.
Chris Sanchez for the record. I also am in support of SB 343. It's great to see responsible management of our advisory boards. 67% of our boards in Nevada are advisory boards, as a matter of a point of interest, I think. In the last 6 years, from 17 to 23, 47 new boards were created, advisory boards were created in Nevada. To see that the Sunset Subcommittee is doing their due diligence and recommending, responsible reductions, I think is something that Nevada should get behind, and I just want to voice my support for the bill. Thank you.
Thank you again for joining us. Anybody else wishing to testify in support of Senate Bill 343? Seeing none in Carson City or Las Vegas, BPS. Anybody wishing to join us over the phone in support of Senate Bill 343?
If you would like to testify in support of Senate Bill 343, please press star 9 now to take your place in the queue. Chair, you have no callers in support at this time.
Thank you. At this time, I'd like to invite those wishing to testify in opposition to Senate Bill 343. If you could please come forward, Carson City or Las Vegas. Seeing none, BPS, do we have anybody wishing to join us over the phone?
If you would like to testify in opposition of Senate Bill 343, please press star 9 now to take your place in the queue. Chair, you have no callers in opposition at this time.
Sounds good. Thank you. And lastly, we'll move to those wishing to testify in the neutral position on Senate Bill 343. Welcome.
Thank you. Good afternoon, Chair, members of the committee. For the record, Alejandro Rodriguez, Nevada System of Higher Education. NC is testifying today as neutral to the restrictions set forth specifically in sections 9 and 10, as those restrictions relate to limitations on the lease, exchange, or sale of the real property now utilized for the state 4-H camp. We note for the record that this is a unique circumstance in the sense that NC took control of this property specifically for the use as a state 4-H camp, and we acknowledge and support that unique restriction. Today, we have no opposition to the legislature's intent to protect that use of that property. Thank you.
And thank you for joining us. Anybody else wishing to testify in the neutral position for Senate Bill 343? Seeing none in person, BPS, can we go to the phone lines neutral for Senate Bill 343?
If you would like to testify neutral for Senate Bill 343, please press star 9 now to take your place in the queue. Chair, you have no callers neutral at this time.
Thank you. Senator Daly, any closing remarks?
Skip Daly again for the record. Thank you, Mr. Chair. Just real quick on this. Sunset Subcommittee, bipartisan, unanimous support on all of the measures that we came forward. So I'm just asking this committee to trust the work of this committee. We did a lot of work, and as you can see, I think we hit on a lot of things. Some of the committees that are being sunsetted are being handled in other areas. So the work is, if there was still work being done, is getting done. And thank you.
Thank you, Senator Daly. With that, we'll go ahead and close out the hearing on Senate Bill 343. Members, I appreciate everybody allowing us to fly through those 4 bill hearings. I do want to let everybody know in the audience that we've now received the food right across the hall from here. There is pizza, wings, and salads. We're going to take a quick 5-minute recess just to allow folk to get some food. And then after that, we'll immediately jump into our Senate Bill 78 hearing. We are in recess for 5 minutes. We will come back at, let's give us 10 minutes. We'll come back at 4:48. We are in recess.
Thank you for ordering all.
The Senate Committee on Government Affairs will come back to order. Thank you all for giving us a quick couple of minutes there to get some lunch, dinner, better said. For those of you who are just joining us, we do have pizza right across from our committee room. Please feel free to grab some. And with that, we'll open up the hearing on Senate Bill 78. Director, whenever you're ready.
Chair Sanchez, for the record, thank you, Chair, and thank you for the food. And did I hear correctly that when it's time for opposition, there's going to be ice cream in the hallway? So I appreciate everybody's time today, and I first want to start by recognizing the over 1,700 appointees, governor appointees serving on our boards and commissions throughout Nevada. These are dedicated citizens that have jobs, families, and a lot of responsibilities, and yet they dedicate their time, their personal time, and their free time to being part of our system of government here in Nevada, and we need to recognize their service, as well as the 320 full-time and part-time staff that support our occupational licensing boards throughout the state. As we've been working on this reform, we at the Department of Business and Industry are very much aware of the sacrifice that our appointees and our staff make, and as we go through this reform agenda, we hope that that will ring true in some of the things that we are doing. As anticipated, this is a pretty lengthy presentation. We'll do our best to move through it as quickly as possible. We're going to do several things here. We're going to highlight the history of kind of how we got to where we are today. Unpack that a little bit, just hitting the finer points as to, in the narrative, if you will, in the framework of what we're doing and how kind of the history has informed where we ended up. Of course, we'll go into the bill, the amendment more importantly. For everybody listening that may not have documents on the BNI website, if you go to the Boards and Commissions link off the homepage, you will see all the documents that we have here in front of us today are there, as well as all the older supporting documents as we've been working through this reform for the last 8 months or so. The first thing I'd like to do just real quick is reference the governor's State of the State, his address. In our state government, we have over 300 boards and commissions, but it's become clear to me that our system of boards lacks the organization, the efficiency, and the accountability that our citizens expect. We know many of these boards are necessary. They provide technical expertise, safeguard public interest, and help keep our communities safe and strong. But we must ask ourselves, are these boards efficiently fulfilling their mission? Are they making the best use of your hard-earned tax dollars, or have they outlived their usefulness? We need an effective system of boards and commissions that reflects the needs and values of Nevada, a system that is smart, lean, and productive. The reform that we are proposing today, that is before you today, meets those objectives as articulated in the governor's State of the State. I want to quickly, right off the bat, mention what this bill is not. There's a lot of conjecture out there and a lot of speculation as to what we're trying to do, and I think it's important to address it right out the gate. This is not a power grab. All the authorities vested in the boards and the Title 54 occupational licensing boards will stay with the Title 54 occupational licensing boards. There is no authority being transferred to the Department of Business and Industry in any instance when it comes to how the current statutes are written pertaining to each individual board. You'll see as we go through the presentation that we have recommended mergers and a change and adjustment to the makeup of the boards, but the funding that the boards receive through their licensing stays with the boards. It will move into the new merge boards, which we will cover in the event that it is a merge board, but the licensing fees, as cases are adjudicated and fines are assessed, none of those things will hit the Department of Business and Industry. And we've modeled this after how we already function at the Department of Business and Industry with our 12 regulatory agencies. Keep in mind, we have almost a $700 million budget. We are a fee-based agency. All of our 12 regulatory agencies are cost allocated for our back-end functions that we provide, and we are taking the same approach with the occupational Title 54 licensing boards. It's not something new that we've created. This is a tried and true methodology that both the GFO, LCB, the legislature, and more importantly, our fiscal staff have been operating under for a long time now, since 1993. We are not in any way changing licensing requirements. We are not in any way in this bill trying to enter into, seek reciprocity. We know that there are separate bills out there that are doing those things. That is not what this reform is aimed at. We are not in any way impacting individual licensing fees. We are not revoking anything, and we are not my term, but I hear this term in a lot of the questions that I get, that this is a cash grab. Again, The funding streams will stay with the occupational Title 54 licensing boards. We are basically going to be charging those boards, the newly reconstituted boards, a fee for the services that we are providing, and we will go into that in great detail. Slide number 4, reform goals. So increased board and commission accountability and transparency. So one of the things that I've been talking about to this body as we've started the legislative session, especially during the budget hearings, as an example, is that we do not have complete line-by-line visibility into the board's finances. Today, all the boards are turning in a P&L statement to the Department of Business and Industry. We hope to receive all of them from, one from each of the 34 boards. And that P&L that we've developed is based on the executive branch budgeting pro forma. It is exactly the same that all of my agencies are responsible for, that my fiscal team has to report to LCB. We didn't come up with anything new. There's nothing new in this instance. What is new is that we were requiring a monthly P&L statement from the boards, and we are going to post those on our website in Business and Industry so that everybody can see in full transparency where all the funding is going for all of our occupational licensing board. Anyone that is paying for an occupational license in this state ought to be able to track the funds that the board in which oversees their profession that goes through that board and see how those funds are spent. Currently, we do not have that level of transparency in our occupational Title 54 licensing boards. Now, that step that I am taking is as a result of SB 431 that passed in the 23 session. It has nothing to do with SB 78, other than this fine point, which I think is the point, is that we don't have the ability to compel. So SB 431 tasked us with oversight, but did not give us any teeth at Business and Industry. Now, as I mentioned, I have 12 regulatory agencies. I have 67 boards and commissions under the Department of Business and Industry. I have 34 boards right now that are operating under 34 different budgeting methodologies, have 34 different contracts for websites, 34 different contracts for IT services, 34 different contracts for lawyers, on and on and on and on. Great services that they seek, that they need to do their jobs. But why do we have to have 34 duplicated instances in every one of those areas as I'm looking at it running an organization that's very large and looking for better efficiency, better use of taxpayer dollars, better use of licensing fees to ensure that we can be the most efficient that we possibly can. Number 2, we want to enhance operations and reduce redundancy. So as I mentioned just a minute ago, we are duplicating. We have lots of redundancy in the current structure. This change that we are proposing will eliminate the redundancy. So phase 1 was SB 431, which gave us that oversight in the 23 session. This is phase 2 of our reform. There will be a phase 3, and we will talk a little bit about what we are doing in the amendment process, which will push the rest of the reform into the 27 session, which will be part of phase 3. Number 3, reduce administrative cost burdens to licensees. We've modeled all this out. We have done a survey it's been about 7 months ago now, where we sent a survey out to all the Title 54 occupational licensing boards, and we asked them about their finances. We then compiled all of that. It informed our budget hearing that we had 2 weeks ago. And in addition to that, we'll go through this in more detail in this presentation. We have the LCB audits that have been conducted since 2013. As we've modeled this out, roughly, we will save more than $15 million annually. In fact, the numbers are a little bit higher than that, but I'm in a public forum, based on what we know, I'm comfortable with $15 million in savings overall to our licensees over time. It's going to be higher than that. I'm lowballing it on purpose because there's still some unknowns there, and we will get at how we will get to that cost savings. 4, provide excellent service delivery. So right now, depending on the license that you hold in Nevada, if you hold a license for a board that's not dialed in their operations, you're not going to get the same level of service as if you hold a license for a different board or a profession that's governed by a different board, and that board has a process in place that moves you through their process quickly, adjudicates their cases quickly. So what I'm saying is that there's no consistency across the fleet of our Title 54 occupational licensing boards, both in how they communicate to their constituents and their licensees, and how they adjudicate cases, and how they engage day to day with, frankly, our office, with the general public, with their practitioners, and with their clients. We need to get a level of consistency across all of our boards. And this also has an economic development component because it's also how they liaise with everybody outside of the state of Nevada that's looking to come into Nevada to possibly hang up their shingle and go to work. And as you know, in many of our professions, we do not have enough Nevadans to fulfill the demand. So we've got to get a better structure in place, and that's what this is about. This reform is about building a better structure, a better system. As I mentioned in the beginning of my remarks, we have great people serving on our boards, but they are operating in a system that is not functioning well, a system that has not been reformed for over 100 years, which I'll get into here in the next couple slides. Number 4, provide excellent service delivery, which I talked about. 5, enhance Nevada's economic competitiveness. I alluded to that, and we'll get into it a little bit more here as we go through. Slide 5, I think it's important to recognize kind of the process that got us to today's hearing. I also want to recognize the internal work, little task force we put together that we committed to the legislature we would do. That was comprised of Brett Harris, our labor commissioner, Homer Sayer, who's Homa, he was here. Thank you, Homa. Appreciate your work. Cara Brown, our administrative law judge, and Dr. Dorian Stoneberger from GoEd. We've met many times just looking at the structure of boards and commissions, doing a comparative analysis, statutory crosswalk, which Nikki will get into. But this timeline gives you the detail of how the steps we've taken since June 2023, how we approach this, what the stakeholder engagement looked like, the surveys that were done. We traveled to Iowa, for instance. We've reached out to dozens of states. We've looked at, I think, probably all 50 states at this point in great detail, and you'll see that in the accompanying material that we're going to be reviewing today. But this is just a brief overview of where we started and where we are. So slide 6 and 7 are the ones that go over the history. I'm a history buff. I can't help it. This is fascinating to me. I do recommend that if you're so inclined in the off-season, so to speak, the discourse in 1875 about a bill that required that physicians receive their medical education from a chartered medical school, and upon establishing residence, register their diploma with the county recorder's office. There's lots of great stuff in there. I'm not going to put a spoiler out, but it is a really fun read about what was going on in the governor's office at the time, and it's all in the legislative record. But it is the first instance of a requirement being placed on a medical profession in the state of Nevada. 1924, the New York Bureau of Municipal Review or Research does a study, submits it to the legislature. It's actually in the legislative archives. It's not in the actual legislative record, but nonetheless, in that review, there was a conclusion that the Nevada state government lacks coordination between the numerous boards, offices, commissions, and agencies of the state administration. 1937, FDR commissions the National Review of the Administrative Management of Government at the federal level. There's a pretty lengthy report that's published, and in that report there is a chapter on boards and commissions at the national level. Why I'm bringing that up and why it's in this timeline is that there is a subsection in that chapter that talks about state boards. And the important conclusion is that the committee at that time concluded that boards were a fourth branch of government at the federal level, unaccountable to the presidency and unaccountable to the Congress. And they say in the report that that methodology rings true in the states, that boards are becoming unaccountable to the governor and unaccountable to the legislature. This is in 1937. 1976, Governor O'Callaghan, he hires a state planning coordinator. His name is Bruce Arkell. This is the first instance that we could find in the historical record, and in fact, Bruce, in his 5-page summary of occupational licensing boards in Nevada that's in the record, indicates that the information from the state's founding to when he did his research is sparse. There's not much there, and that rings true with our research as well. In fact, he did not cite the New York Bureau of Municipal Research report. I don't know that he was aware of it. But he did conclude that boards had administrative inconsistencies resulting from a lack of coordination and difficulty performing administrative functions due to a lack of support. He called it a lack of synchronization amongst the boards. So what's developing here as we get from 1875, 1924, 1976, and then as we go through this list, you'll see about every 50 years there is a notion that we probably ought to reform boards in the state of Nevada. What we have in 2008 is the SAGE Commission is created. 2010, their research is conducted. 2011, they make a recommendation to the state legislature to set up the Sunset Subcommittee. And in 2013, the first report is submitted. From 2013 to 2023, 35 advisory boards and commissions are recommended for elimination. During that same time frame, 13 boards are eliminated, and from the 17 to the 23 session, 43 new boards are created. So we are in an instance where we are creating more boards than we are eliminating, and this is an important factor because we are at a point where we are having a hard time getting Nevadans to serve on boards. We don't have enough Nevadans to serve on the boards that we have now. It is a continual struggle. I have had the pleasure to work under the last 3 administrations, and each of the governors that I have worked with have had issues filling the slots for all the board appointees that they have. There is, as I mentioned, 1,718 at the moment. And there are many bills this session that will create more advisory boards. So we have an issue here where we are seeking to reduce the number of appointees. The reform for the Title 54 licensing boards is a reduction of 100 appointees for the Title 54 boards. And as we unpack what we envision doing with those boards, you'll see where we pick the, reduce that 100. I think at this juncture, I'll just allude to this, and Nikki will cover it. But in our amendment, we are removing all instances in the proposed language of SB 78 that refer to advisory boards. That is part of what we are going to kick to the 27 session for the rest of the boards and commissions review, so that we can stay entirely focused in this session on Title 54 occupational licensing boards. So all the references in the bill, which Nikki will go over in detail section by section, where we have advisory boards listed, we will be striking those out with our amendment. So moving on to slide 8, and that's boards and commissions reform, the skeleton bill. As far as we can tell, we have I guess it's a distinction, I don't know, good or bad, but we're the only skeleton bill in the session, this session. We had to look up what a skeleton bill was. I'd never heard of it. In fact, a lot of the members of folks we were meeting with had never heard of one either. You know, it would have been our desire to have a full bill draft, but it is what it is. So here we are, we have this. With the amendment that we're making, about 2/3 of the bill is struck out, and it'll be, just like I say, be the Title 54. But as written, just so that what's in the bill as it currently stands, before we go over the amendment, since Nevada's founding in 1864, the number of regulatory, advisory, and licensing boards and commissions has ballooned to over 300. We're roughly at about under 320. Interesting fact, I think, is that when we initially took on this effort at the direction of the governor, the list that we had 220 boards. So after about 6 months, that went up to about 318. I can't sit here before you today and tell you that that's all the boards that exist, because I'm sure there's some I don't know about yet. And the more we talk about this, the more awareness there is in the public. We find out there's other boards, which to me is kind of fascinating. Here we are in this day and age, and that's the case, but it is the case. Yeah, easy to establish, difficult to eliminate. I think I hit on that. I talked about 67% of the boards being advisory boards. Fourth branch of government. One of the things that I think is important, you know, there was a Goldwater study that was done in 2020, and it was about entrepreneurship. And one of the things that it found was that our lower income populations are more adversely affected by occupational licenses. And why that matters is that we are the highest occupational license state in the nation. And we have the highest amount of requirements for our license than any state in the nation. And there is an artificial ceiling that has been put over individuals that are seeking to work their way out of poverty, that would like to get an occupational licensing and practice in a given field. This is not me saying this. Well, everything that I'm saying is backed up by many studies, and all these things are available on our site, as well as in the bibliography of our policy paper. We consulted many different in this effort, many different sources, which I'll get into a little bit more detail as we go through. But nonetheless, in the economic data is pretty clear. Morris Kleiner is probably the most published economist on occupational licensing boards in the nation. The Obama administration cited him in 2015 when they went in and did their assessment. He's been cited by the Institute for Justice. Just about anybody that's looked at occupational licensing boards in the country, and any report that any state has put out of any substance, has cited his work. And we have done the same in our policy paper, and that has informed much of what we're talking about here with respect to the economic impact. The other thing that we're solving for is antitrust. This originates out of the 2014 North Carolina State Board of Dental Examiners versus the Federal Trade Commission. The court concluded essentially that there's two components of this. If a state had adequate supervision, it could mitigate the antitrust exposure, and the Supreme Court talked about dominance. Dominance is when you have the majority of the board's members are licensed by the board on which they sit. And then in taking action, if they make a quorum, they could potentially violate antitrust. This is an area that we didn't get a lot of clarity in our research over the last 8 months about, did Nevada have adequate supervision? Was SB 431 sufficient? And we thought as we went into this, because we couldn't get consensus in the conversations we were having, that we would address it in 78 once and for all. So what you will see as we move into the actual board makeup and proposals, we have board mergers, and then we have the addressing the dominance issues. And I'll return to that here in a minute, but I want to turn it over to Nikki for the next section.
Thank you. Nikki Haig, for the record, Deputy Director of Business and Industry over the Office of Boards, Commissions, and Council Standards. SB 78's amendment, what we are proposing to amend from the bill as introduced are sections 1, sections 17 through 22, sections 24, 3A through YYY, sections 26, sections 27, 28, 29, sections 30 through 78, sections 85, section 90, section 95 through 96. In those amendments, what we are asking through that amendment process would be to strike all sections introducing new advisory bodies within the executive branch of state government, remove any sections proposing the modification of existing advisory bodies as reverted to the original statutory language, remove all new provisions introduced in the bill that are in blue text and refer to the creation, modification, or consolidation of advisory bodies, remove provisions consolidating existing advisory councils into new entities unless otherwise stated, ensure all references to new advisory councils, committees, or boards throughout the bill are removed or amended to revert to their pre-existing structures or statutory conditions unless otherwise stated, and removing the schedule reviews and automatic termination provisions. With these amendments, the fiscal notes that are in the system right now will go away. Those fiscal notes are addressing the advisory bodies. The next slide, the current challenges that we are currently having on the implementation of our occupational and licensing oversight. No funding, staffing, equipment, or operational expenses. Without the staff, the office has not been able to effectively monitor or support Title 54 boards. Unable to solicit for contract help or research for implementation of SB 431. Unable to rely on other departments within the Department of Business and Industry for support due to restrictions in NRS. Without funding, unable to set up framework for the office operation, including technology, policy, or procedures. Insufficient capacity to engage with boards or provide clear guidance that was established by SB 431. Boards have not been able to continue operating consistently due to lack of centralized guidance. With no staff, unable to fully investigate constituent and licensees' complaints regarding boards, and the resistance from the boards and board staff on the compliance of SB 431.
So this goes at, Chris Sanchez for the record, sorry for that. This goes back to the comment that I made about the cost allocation methodology that we currently use with our regulatory agencies. So that same model is being applied to our occupational Title 54 boards, in which we will stand up the administrative capacity, and then those services will be billed to the boards. As the presentation continues here, we actually show where the finances are to our knowledge with the boards and how that will work. So bear with us as we work our way through this. Slide 11, Boards and Commissions Reform, SB 78. So this gets back to kind of the governor's statement that I read in the beginning of the presentation: accountability and transparency, strong oversight and accountability, standardized enforcement, reduced policy inconsistencies, fiscal transparency, moves board finances into the state treasurer's office. We have $43 million in reserves, sitting in reserve accounts in our occupational licensing boards. For some of those boards, that's 27 years of reserves for operations. It's about 90 days, I believe, is the requirement for state agencies if they in their own reserves. And so, you know, we have several questions around those that we're trying to unpack right now, which is how much of those are under the auspices of the treasurer's office and being overseen by the treasurer's office, as all of the reserves are in the executive branch currently. Not saying there's anything wrong there, but we're checking all that out. But there is about $43 million in reserves. Contested case hearings and disciplinary matters ensures fair, consistent enforcement. Centralized website and public records enhances licensing, accessibility, transparency, and public engagement. You know, the two best sites we've seen nationally are Arkansas and Iowa. If anybody's curious as to where we want to go with the website design, those are the two states to look at. We have been in contact with their equivalents to OCIO and their contractors, looking at how we can build out a site here, or frankly, still theirs, and save money. But the idea is that one-stop shop. One-stop shop, whether you're someone looking to move into the state, whether you are a current licensee, whether you are a board member on a board, all the information you need in any one of those categories will be on that website for everybody to see. And for full transparency, all the financials for the boards, where their reserve dollars are, how they're invested, if they're invested, all of that will be on that website. And the nice thing is we don't have to create it from scratch. It already exists. We've surveyed the states. Those two we think are the most robust. Of course, we'll make it look like what we think it should look like here in Nevada, and that'll be done in partnership with all of our boards. Next section, reduce redundancy and administrative costs. Uniform policies and standards ensures consistency across all boards regardless of board size and number of licensees. That gets at what I talked about earlier, where the level of service that you receive should not be based on whether or not your board has enough resources to provide that service. Cost savings, reduces duplication, lowers administrative overhead, salaries, benefits, resources, and licensing. One thing I will say in this, and I think it's important to say this outright on the record, I'm not looking to put people out of work. I know what it's like to be out of work. I've been in Cashman Center in a line with 3,000 people with my resume in hand trying to get a job. I get it. We're not trying to put people out of work with this. I mentioned we got 318 folks right now that are full-time and part-time staff for our boards. We will work with the Department of Administration. As all of you know, we have about a 17% vacancy rate right now across the state and state government. That's thousands of positions, unfortunately, that are available in state government. So we will work to find folks positions, but we are not eliminating all the positions under the boards. That's important to know. We are standing up 70 positions within the Department of Business and Industry, but those 70 positions are informed on the surveys that we've done of our boards to quantify how much administrative work is done by those boards currently. We are only taking on the administrative function. The experts, the folks that have the institutional memory, the attorneys that have been practicing law in those areas for decades that have worked with the boards, they will still work with the boards. We're not going to upend all that. I need to be able to flip a switch off and one switch on in terms of this reform and accountability without actually impacting anything the boards are doing. In order to do that, I've got to have those folks that know those things, that know those industries, have served those industries, have been in the trenches in those industries and working. So this is not a cost savings measure in which we're going to put a bunch of people out of work. It is not that at all. There will be folks that can be absorbed if they so choose to work at business and industry. Some folks may not want to. We will also, as I mentioned, work with administration. So if those folks choose or would like to get a job in a different agency, they can. I can't tell you today that no one will lose a job, but it is my goal to ensure that there is minimal job loss in this transition, should this bill make it through the legislature. Specialized support, IT provides legal, HR, investigation, auditing, and financial services. We do this now, as I mentioned, with our regulatory agencies. For perspective, boards and commissions at their current $42 million in revenue is 1/14 of the size of my budget at business and industry. So in terms of us being able to handle this and bring this in-house, again, it's 1/14 of what we currently do. And so we have capacity in terms of the knowledge and what it takes to stand it up, what it should look like. We don't have to go invent anything. We have everything done in the spreadsheets. All we have to do is migrate it over and plug in the information and then make sure we've got the staff that can work with the boards to work through that process over time. Administrative efficiency, streamlines payroll, benefits, and operations, dedicated attorneys and legal support. We will have administrative law judges, we envision anyway, within the Department of Business and Industry under Nikki's division. They will be able to lend additional support. That is not to circumvent the AG support. That will still be there. Many of the boards have lawyers, as I mentioned, that are very seasoned. Those folks will still be there. But we will have the ability to help adjudicate cases in the instances there are backlogs or from some of our smaller boards that just don't have enough money or resources to afford bringing in folks that can do that work. Again, I'm trying to get consistent service delivery across all occupational licensing boards, regardless of the licensing, the individual license. Enhance Nevada's economic competitiveness. Procurement and contracting, standardized vendor selection, and cost management. Not every board approaches contracting the same way. As all of you know, being in the legislative body and having oversight over different time in my life, the state budget, there's a process we have to go through for contracting. There's transparency requirements, there's posting requirements. That is not consistently applied across all of our boards, and we need to make sure that it is, that it comports with how the Department of Administration has structured the regs and how we are to do things as executive branch agencies. And because those boards are now under the Department of Business and Industry with passage of SB 431 in 2023, I am responsible for that. And so we've got to make sure that we do it right and that we get that information out to the public. Bill draft requests. Look, there's been a lot of, I think, speculation about how this will work. I completely understand from the board perspective that these folks are the experts in their industries, and they have individual lobbyists that they've worked with over time. They're experts in those industries. I do understand that. The challenge that that we have is that, and this is something that we're going to have to probably work through together, both the legislative body and the boards. But I don't see the scenario where one board hires a lobbyist, comes to the legislature, and fights the lobbyist from another board on a policy issue. I don't know that that's productive, because there's a loser in that equation, and we're all Nevadans, and that means some of our fellow Nevadans are losing. And that doesn't really make sense. And there was a lot of conversations that I got in over the last 8 months with individual boards, and many of them referenced, no joke, in session, whatever, 10, 15 years ago, we won. We won. We got this done. And I talked to the board on the other end of the equation that lost. To me, that's not a healthy dynamic. I don't think that serves Nevadans well. I think those policy conversations should be had a little differently. And now that the boards are under the Department of Business and Industry, we can do those conversations much like we do in the regulatory space for business, for the agency. Standardizing licensing, uniform occupational licensing systems across Nevada, and phase transition. And we will get into how we envision actually doing all this and the implementation phase with that phase transition here in, well, probably 10 slides.
Take for the record. SB 78 amendments required. Once again, removing all of the advisory bodies, commissions and councils. We have developed 2 budget amendments to add for our supported staff. One of those budget amendments has 14 staff members. The other budget amendment brings in the additional 50 staff. Merge the Title 54 occupational and licensing boards, adding staffing and administration for B&I to work with DHRM, and we will also be working with state purchasing and the AG's office on the contracts. We're requesting to leave the Commission on Post-Secondary Education with Dieter. SB 71 brought that commission over to Business and Industry under the Office of Boards and Commissions, but it left their support staff and the budget over at Dieter. So we're requesting to keep this particular board at Dieter with their budget and with their staff. Adjust board compensation to prevent dominant issues. And then, of course, we have the policy paper and the link to the policy paper that Chris and I worked on over this past year. Slide 13. So this is the merged board structure that we have. It reduces 20 boards to 6 new boards and 1 advisory board. This covers sections 86, 89, and 90 of the bill. We will be creating the Nevada Board of Rehabilitative Practice and Therapy, the Nevada Behavioral Wellness Alliance Board, the Nevada Medical Board, the Nevada Optometry Dispensing Opticians Board, the Nevada Board of Engineering, Surveying, and Environmental Health, the Nevada Board of Architect, Design, and Landscapes, and then we will be creating 1 advisory body combined together of the Oriental Medicine and Homeopathic Advisory Committee. That committee will actually be working directly will fall under the Department of Business and Industry. The board merge methodology that we came up with on creating these merge boards, again, was taking 34 boards, reducing that down to 18. We created 6 merged boards and then 1 advisory committee. 37 boards were transferred over to Business and Industry with SB 431 in the last session, but 3 of those are advisory bodies that fall under, 1 falls under the Contractors Board, 1 under the Nursing Board, and 1 under the Dental Board, that we would like to just, those advisory bodies remain at those, within those larger boards, and we're focusing more on the 34 instead of the 37. The crosswalk, what we did in looking at the methodology is we did a crosswalk of all the statutory review of all of the Title 54 boards. We crosswalked the board's duties for duplication and like responsibilities, licensing, regulation, rulemaking, and enforcement. We aligned boards with similar or complementary scopes. We assessed the number of licensees, the volume of complaints, and also the cases that were investigated. Part of the methodology, we also reviewed other states' board structures and consolidation models. We held stakeholder engagement, Feedback led to important changes to board compensation and representation to ensure all professions had a voice. One thing that we wanted to make sure, and through all of these merged boards and the consolidations, was that every profession still had a voice on these occupational boards. We started off in the mindset of having 7 to 9 member boards. Through the stakeholder engagements with the executive directors, with the chairs, and people within the industry, we moved some of those boards up to 13-member boards so that we could make sure that that each profession still had a voice on these boards. So I think that's important to know, is that is one thing that is important to us, is to make sure that everybody still has a voice, everybody in these professions would still have a position on these new merged boards. Next slides I'm going to be going through are part of amendment number 4 on the amendment page. The existing requirements for all board members will remain unchanged in the updated proposed language unless otherwise stated in the amendment. So slide 16, the Nevada Board of Rehabilitative Practice and Therapy. This is section 89 of the bill. The four boards that we will be merging together are the Board of Athletic Trainers, the Nevada Board of Physical Therapy, the Board of Occupational Therapy, and the Speech Language Pathology, Audiology, and Hearing Dispensing Board. The new board makeup would be 2 licensed physical therapists, 1 licensed physical therapist assistant, 2 licensed occupational therapists, 1 occupational licensed assistant, 2 licensed athletic trainers, 2 licensed speech pathologists, 1 licensed audiologist, 1 hearing aid specialist, and 1 general public member. Key similarities that we found with these boards in doing their crosswalks is their regulation of health professions, licensing authority, disciplinary actions, public protection mandates, and the athletic trainers and physical therapists on their dry needling. Other states that have similar boards that have this board mergers together were Ohio, Alaska, Delaware, Iowa, Georgia, Massachusetts, and North Carolina. Slide 17, the Nevada Board of Architecture, Design, and Landscapes. That's combining the Board of Architecture, Interior Design, and Residential Design with the Board of Landscape Architect. The new board makeup would be 3 registered architects, 2 landscape architects, 1 registered residential designer, 1 interior designer, 1 general public member, and 1 specialized public member, looking into in the industry of expert construction, engineering, environmental planning, or real estate development. There are key similarities in their crosswalks of what their board duties were are licensing, credentialing, adoption and regulation, investigation and disciplinary authority, protection of public health, continuing education, fees, and financial oversight. Other states who have boards that oversee similar bodies are Texas, Arkansas, Hawaii, Mississippi, Maine, New Jersey, Oklahoma, and Wisconsin. Number 3, the Nevada Behavioral Wellness Alliance Board. That takes the Nevada Applied Behavioral Analysis Board, the Nevada Board of Marriage and Family Therapists and Clinical Professional Counselors, the Nevada Board of Examiners for Social Workers, the Nevada Board of Psychological Examiners, and the Alcohol, Drug, and Gambling Counselors. This is a 13-member board, 1 licensed behavioral analysis or assistant behavioral analysis, 2 licensed marriage and family therapists, 1 licensed clinical professional counselor, 2 licensed social workers, 1 licensed psychologist, 1 licensed clinical alcohol and drug counselor or alcohol and drug counselor, 1 licensed problem gambling counselor, a general public member representing healthcare for indigent or uninsured persons, 1 member representing an academic or training institution, and 1 licensed or certified member from any of the represented fields. Other states that have similar combining boards, there are not a lot of states that combined all of these professions together, but there are professions that deal in behavioral health, and they don't have these exact boards, but they do have similar boards that are merged together. And that's California, Florida, Georgia, Idaho, Oregon, Virginia, Arizona, Utah, Maryland, and Texas. Number 4, the Board of Medical Examiners. This combines 4 boards together: the Board of Medical Examiners, the State Board of Osteopathic Medicine, the Chiropractic Physicians Board of Nevada, and the State Board of Podiatry. 4 licensed medical doctors, 2 licensed osteopathic doctors, 1 licensed physician assistant, 1 licensed respiratory care practitioner, 2 licensed chiropractic physicians, 1 licensed podiatrist, 1 general public member, and 1 member representing indigent and uninsured healthcare interest. Key similarities with these boards are the regulatory authority, licensing and disciplinary, investigation, enforcement of powers, rulemaking authority, and consumer protection and public interest. The Federation of State Medical Boards states that 13 states have separate MD and DOs, and 37 states have combined their MDs and DO boards together. States with all 4 of these professions combined together are Virginia and Kansas. In states with 3 of the 4 are Alaska, Illinois, Hawaii, Mississippi, Montana, New Jersey, New Mexico, Ohio, and Oregon. The Nevada Board of Engineering, Surveying, and Environmental Health is in Section 80 of the bill. This puts together the State Board of Professional Engineers and Land Surveyors and the Board of Environmental Health Specialists, with 4 professional engineers, 1 land surveyor, 2 environmental health specialists, 1 general public member, and the chief medical officer who currently is also on the Board of Environmental Health Specialists. Key similarities are licensing and credentialing, regulations and standards, complying investigation and disciplinary authority, protection of public health, safety and welfare, fairs, continuing education and professional standards, fees, and financial oversight. No other states have this exact merge, but both these boards continue to contribute to Nevada's public infrastructure, natural resources, and built environment. Their paths cross with water systems, site planning, land use development, hazardous material, and public health. And 6, the Nevada Optometry and Dispensing Opticians Board. This is merging the Nevada State Board of Optometry and the Board of Dispensing Opticians. The new board makeup would be 3 licensed optometrists, 2 licensed dispensing opticians, 1 general public member, and 1 member who represents the indigent and uninsured healthcare interest. Key similarities of these 2 board mergers would be their licensure, regulations, investigations, hearings, adoption of regs, records, and reporting, and 2 states have these 2 boards merged together, which are Ohio and California. The last is the Oriental and Homeopathic Advisory Committee, merging the Nevada State Board of Oriental Medicine and the Nevada Board of Homeopathic Medical Examiners. The board makeup would have 1 MD or DO, 2 licensed Oriental medicine practitioners, and 2 advanced certified homeopathic practitioners. This this advisory committee would report directly to the Office of Boards, Commissions, and Council Standards, ensuring continued expertise in the specialized fields while maintaining efficiency and regulatory consistency. Approximately 44 states regulate acupuncture. I have found 9 have standalone boards. A handful of states have standalone acupuncture boards, and many others either are integrated into larger medical boards or an advisory body that falls under a department. Nevada is the only state that has a homeopathic medicine board. Both of these professions are not universally licensed in all states.
Chris Sanchez for the record on slide 23. This provides more detail. There was on the antitrust issue that I mentioned earlier in the presentation. So the title of the paper that was written that we referenced was called Foxes at the Hen House, Occupational Licensing Boards Up Close. This was written by an antitrust lawyer named Rebecca Allensworth. In there, you will see that at the time of the study, which was published under the California Law Review in 2017, Nevada had about 83% of its boards had dominance issues. That same author last month published a book. It's How We Decide Who is Allowed to Work and Why It Goes Wrong. And for more detail into the reforms that we're doing here, they're outlined in this book. She spent 4 years embedded in Tennessee's occupational licensing boards, in addition to all the national research that she had done back in 17, and which we pulled for this presentation and for our policy paper. I wish I could claim the intellectual property in terms of all the ideas and everything that are baked into what we did here, but there's a lot that was pulled from her work, and I mentioned Kleiner's work and others that have been in this space and working both as economists and attorneys and folks that have served on boards throughout the states. It's worth a look, I think, if there's anybody that's really interested in this policy reform. But nonetheless, getting back to the point, 83% of the boards that were surveyed at that time, which is our occupational licensing boards, had 83% dominant issues in 2017. So with that in mind, I'll turn it over to Nikki to talk about the restructuring of those standalone boards.
So of the 34 boards that we had, taking away the merged boards, that left us with 12 independent standalone boards. Of those 12, only 2 boards did not have dominance issues. That was the funeral board and the nursing board. All of the other boards listed here all had those dominance issues, and so we looked at the restructuring of those boards, and I'll go over each one of those individual boards now. And these restructures are also in the amendment that we have proposed. So the Nevada Board of Accountancy, this board had 85.7% industry dominance with 6 certified public accountants and 1 general public member. The new board would give 4 licensed certified public accountants, a tax attorney or compliance expert, 1 general public member. As I stated, the current board has 85.7% dominance issues. The revised board would have 57.1 CPAs, 42.9 would be the oversight, making it a more balanced and fair regulation. Public and expert oversight at 42.9 strengthens consumer protection, fraud prevention, and ethical financial practice. A tax attorney provides critical legal expertise on financial compliance and corporate accountability. And industry professionals still have a strong input at 57.1%, but must work collaboratively with the external voices of that board. Number 2 is the state Barbers Health and Sanitation Board. That board currently has 75% dominant industry dominance. It has 3 licensed barbers at 75% and then 1 chief medical examiner at 25%. The new board makeup would have 2 licensed barbers, 2 general public members, and keeping on the chief medical officer. The current board has no general public representation to advocate for consumer protection or fairness. The revised board at 40% barbers, 40% public, and 20% health expert is more balanced and ensures fair regulation. This enhances consumer protection, improves sanitation compliance, and ensures accountability in the industry while still preserving essential industry expertise. The certified court reporters, this board has 60% industry dominance in their current board makeup. They have currently 3 certified court reporters, an attorney, and 1 general public member. The new board makeup would have 2 certified court reporters, an attorney, a general public member, and a consumer representation or business professional. Revised board structure is more balanced and prevents dominance. Industry professionals would be at 40%, provide expertise but do not control the decision, and external oversight would be at 60%, ensuring fairness and consumer protection. The Nevada State Contractors Board. This board has 85.7% industry dominance. It has 6 licensed contractors and 1 general public member. The new proposed board would have 4 licensed contractors, 2 who reside in Clark County, 1 who resides in Washoe County, and 1 who would reside in the rural counties. 3 general public members, again, 1 in Clark County, 1 in Washoe County, and 1 in a rural county. 1 legal consumer protection expert, a business leader, construction law attorney, or a compliance expert are examples. In a financial business expert, examples of that could be an accountant, a real estate developer, or a construction finance expert. Contractors still hold influence but no longer dominate the board. Public oversight is strengthened by 34%, ensuring fair consumer protection. legal and financial professionals at 22%, and accountability, expertise, and fairness. And this revised board structure prevents regulatory capture, ensuring transparency and balance. Nevada State Board of Cosmetology, its current board member has 71.4% industry dominance. It has 4 licensed cosmetologists, 1 licensed nail technologist, a licensed esthetician, and 1 general public member. The new board makeup would be 3 licensed cosmetologists, 1 nail tech, 1 licensed esthetician, 1 general public member, and a health and safety representative. The revised board would be 71.4 industry professionals, 28% oversight is more balanced and ensures fair regulation. Public and health oversight at 28.6% strengthens consumer protection and safety. Industry professionals still have a strong input, but must work collaboratively with the external voices. Number 6, the Nevada State Board of Dental Examiners. They are at 81.8% industry dominance, with 6 licensed dentists, 3 licensed dental hygienists or therapists, 1 indigent and uninsured healthcare, and 1 general public member. The new board makeup would give 4 licensed dentists, 2 licensed dental hygienists or therapists, 3 general public members, 1 health and safety representative, and 1 indigent and uninsured healthcare. The revised board would have 54.6% industry professionals, 45.5% independent oversight, having the more balanced in ensuring the fair regulation. Public and expert oversight is 45.4%, strengthens consumer protection, healthcare access, and health safety. And industry professionals still have a strong input at 54.6%. And slide 31, the Nevada State Board of Massage Therapy. They are at 88.9% industry dominance. They have 6 massage therapists, 1 licensed reflexologist, 1 licensed structural interrogation practitioner, 1 general public member, and a advisory law enforcement that is non-voting. The new board makeup would have the 4 licensed massage therapists, 1 licensed reflexologist, a licensed structural interrogation practitioner, 1 human trafficking prevention advocate, 2 general public members, and it's keeping on the non-voting law enforcement member. Slide 32, the Board of Pharmacy has 85.7% dominance issues. They have 6 registered pharmacists and 1 general public member. The new board makeup would be 4 registered pharmacists, a healthcare professional, that could be a physician, a nurse, a hospital administrator with experience in medicine, and a general public member. Let me see. So it's got 4 registered pharmacists, 1 healthcare professional, and 2 general public members. The current board has 85.7% dominance, which regulates their own profession. Decisions on pharmacy discipline, opioid regulation, drug pricing, and patient safety are controlled by the pharmacists. The revised board would have 57.1 pharmacists, 42.8% in oversight. Public and expert oversight would be 42.9, strengthening the consumer protection, medication affordability, and the opioid safety policy. And industry professionals still have a strong input at 57.1%. The Private Investigator Licensing Board has 80% dominance, 4 private investigators and 1 general public member currently. The new board makeup would be 2 licensed private investigators, 1 licensed security professional or licensed repossession agent, and 2 general public members. Industry professionals would be at 60%, retaining expertise, but must collaborate with the public representation at 40%. Public oversight at 40% represents regulatory capture and promotes fairness in licensing, discipline, and enforcement. And 10, Nevada State Board of Veterinary and Medical Examiners. This current board makeup is at 87.5 industry dominance. They have 6 licensed veterinarians, 1 licensed veterinary tech, and 1 general public member. We are proposing 4 licensed veterinarians, 1 licensed vet tech, and 2 general public members. This would give the board, the current board, again, is at 87.5% industry control. The revised board would be at 57.1% veterinary, 42% oversight, is more balanced and ensures fair regulation. Industry professionals still have 57.1, but must work collaboratively. And the new 7-member board prevents voting deadlocks while maintaining fair structure.
Chris Sanchez for the record, and one final point on the dominance issue is that with these proposed, reworked boards, this makeup combined with the supervisory function that's in the bill, we think that we've sufficiently mitigated that risk. Slide 35, phased implementation plan. So with the merge boards that Nikki went over, it's going to be a process to do this and do it systematically and thoughtfully. So you will notice in the bill, there's nothing that says, July 1st of this year, for instance, for implementation. We fully expect to take a 2-year period for implementation when it comes to the merge boards, where we would do about 1 board a quarter, roughly, in partnership with the boards to be merged. So, we would bring them all together, we would do a staff review, we would look at, these numbers are just for illustrative purposes. If we had 5 boards, and there was 10 staff on those boards, we would look at what percentage of those staff are fulfilling administrative functions. That would be the functions that would transfer into the Department of Business and Industry. Administrative is, as we look at it, is the folks that are facilitating their contracts, maybe managing their IT, their websites, things like that. Not administrative in the context of, helping with the adjudication of the cases in that space. So we would have to go in and do that analysis with those boards that are going to be merged in that quarter to define those percentages and then make sure that we bring those staff into business and industry, which would cause a realignment of some of the staff in the boards that would then move over to the new merge board. I mentioned earlier that the authorities will migrate over to the new merge board, those staff would move over to the new merge board, and those funds that are in those accounts stay with the now merge board. They do not come into business and industry. That is true of the reserves as well. Because again, we are just charging a cost allocation, which is basically a fee for service for that percentage that we absorbed in the department to provide that administrative function. So what we envision, as Nikki went into and what we presented a couple weeks ago into our budget hearing, another 2-hour hearing for those that are so inclined to kind of go back and watch that. But essentially, we have, in SB 431, there was no staff that accompanied phase 1 of the reform. So the bill passed, but it was not funded. So there is, in the budget amendments, there is a 14 staff that would have brought us current for the oversight piece. We're layering on top of that the reform piece, which is SB 78, which is 50 staff. We have 2 staff that are right now in the, 1 person in the general fund, that's Nikki. 1 additional staff that we request in the budget that would be under general fund. This is for a very short period of time. When we start the merge process, and then the non-merged boards, we will be absorbing their administrative functions first. So as we do that with the non-merged boards, we will then be able to move Nikki and Nikki, if everything were to pass and we were able to hire that support person, they would move off of the general fund funds after we think about the first year of the biennium, and then we would be bringing on staff as we went through implementation of the bringing in those administrative functions. We outline that roughly here on page 35 and how we envision that will work.
Nikki Haig for the record. So with the LCB Audit Division, they do a biannual status report on audits for certain state boards. These are the boards that have multiple year findings. Slide 37 is more of a breakdown of what those findings are. So every January, the LCB Audit Division posts on their LCB Audit website the findings of those reports. These slides on the bottom left-hand side has a link to those reports. So these are the reports starting from January 2013 through January of 2025. And it lists out what those financial reports are and what findings that the boards or that those audits that are brought forward and it shows what the findings were. If you want to look to see what more detail is, the majority of them are just the boards not submitting their financial reports, having weak internal controls, questionable expenses. Some do have theft, audit reports with disclaimer of opinions. There's quite a lot of different findings that LCB does find in these reports. They're very informational if you do go back and look at those. So again, the slides 37 and 38 just outlines what the findings are that LCB is looking at or finding in these reports with their audits.
Slide 30, Chris Sanchez for the record, slide 39 is a summary that goes back to the initial report that was done all the way up through 2024. We updated this slide from our budget hearing as we were able to pull the most recent LCB report that was published and incorporate that here. These are the boards that have, the amount of boards that have deficits. So you'll see the calendar year reported, the boards recorded an LCB report, the number of those boards, and then the boards with expenses that exceed revenue. So for instance, 2024, we had 32 boards reported. 16 of those boards had expenses that exceeded revenue. 50% was the percentage, and then it gives you the breakdown of the funds. Now, it's important to recognize these are LCB, legislatively generated LCB reports. These are not business and industry reports. We've linked, or you can look at those on the LCB website. And additionally, on slide 40, we do the revenue and expenditures by board breakdown, and you can see the expenditures and revenue per board, both the amount of that revenue and then where they either are exceeding in revenue or at a deficit. And that's based on the information that's basically presented in those reports as well. Slide 41 gives you the same, but a more focused review of the top 10 boards in terms of the revenue and where they sit. This is all current as of the last LCB report. We've updated it since the budget hearing. And I'll turn for the last part of the presentation before closing to Nikki.
Nikki Haig for the record. So the last three slides, I'm not going to go over each one of these slides in detail. This was really just a case study that we did in business and industry. It was one of the first boards that were brought to our attention that had several issues with this board starting from 2006 to current. This is a board that has owed the Attorney General's office money. This is a board that has spent over their revenue. Sunset Subcommittee in 2019 had a report that the board failed to justify its continued existence. At that time, the debt had more than doubled, and it was at $175,000 that the board was in debt to with the AG's office and other contracts that were out there. The board at that time was recommended to terminate, and it did not. It was not terminated. Again, this is a board that is only in Nevada. The homeopathic board is a board that currently is only in Nevada. In 2016, Arizona eliminated their board, and at that time, Nevada and Arizona were the only two boards that had a homeopathic board. Currently, we've had issues with their secretary treasurer who paid himself $15,000 without required signatures. That board was in violation of their own bylaws. Their bylaws state that 3 members have to be on the signature at the bank. The secretary treasurer was the only person who had a signature card on the bank. The president and the vice president were not on those signature cards. Director Sanchez and I had to go and contact the president of the bank that they are with to have a conversation with them to let them know that they were in violation of their own bylaws, and requested that they made sure that the president and the vice president were on that signature card. The board also continues to have issues with that secretary treasurer. It ended up going to the Ethics Commission. The Ethics Commission did find violations. They've asked that secretary treasurer to provide the homeopathic board their usernames and passwords so that they could get into their website, so they could get into their constituent emails, so that they would be able to get into their QuickBooks. At this point, the homeopathic board does not have a website. The Secretary or Treasurer has not provided all of these passwords and information that was requested by the Ethics Commission to be handed over to the Homeopathic Board. So the Homeopathic Board is currently working with OCIO to try to develop a new website. So this is a board that, and not to pick on them by any means at all, but this again was one board that was brought to our attention early on. And looking into it, this is things that can happen to a board that does not have oversight and accountability. If anything could go wrong, it has happened to this board. And so you're more than welcome to look through those slides to see what all we have uncovered. They currently, on the 24 investigation, their revenue was at $21,550. Their expenses was at $41,659.
And their debt is?
Right now, their current debt that they owe, or their current bill that they do owe to the AG's office that started out at 175 has gone to 116. So they still owe money to the AG's office that, if you're looking at what they make, they are unable to pay this debt.
Chris Sanchez for the record. So I wanted to end on a high note. I know this is not a high note, but it's illustrative of the challenges that we face with our boards. It is the most egregious, which is why we've included it as a case study. Unfortunately, and there's an important thing that Nikki said, I had to go to the bank president and ask the bank president to add individuals onto that account card. There's no accountability. The only recourse that we have right now with our current structure and statute is for the governor to remove governor-appointed members of the board. So this is a board that, even though LCB, since 2006, almost 20 years, has called out issues with it, year after year. The issues change. The issues somewhat stay the same. But here we are almost 20 years later dealing with this board. There was an instance where there was a gap in their ability to be able to process licensing, to keep licenses current. That's unacceptable for a board that is responsible for seeing patients. Our system, our structure that we have in place ought to prevent those things from happening and protect the welfare of the public of Nevada. And right now, the way the system is structured, we cannot do that effectively and efficiently to make sure that our citizens are safe. So I will end where I started. We have a tremendous amount of respect for everybody that's been appointed to boards, that's serving on boards currently, and for the staff. This is not and I know because people are passionate about what they do, and I respect that. This is not an attack on any individual. We have, again, a system in place that needs reform. It has been 100 years in the making, with very soft poking around at the edges without real comprehensive reform. Iowa was the first state in the nation in April of last year to pass comprehensive board reform. If this legislature goes forward with this bill, we'll be the second in the nation for full board reform. And that, I think, is pretty commendable for us in Nevada because we tend to lag. As we called out in the presentation, we looked at all the states and how their boards were structured. Everything that we have presented, it's not the first instance of it. We, in our research, have gone back and seen who's done it, what the feedback was, what the National Association said in those hearings in those states, and what the feedback was of those boards when it is on the record. So that'll conclude our official remarks, and we'll stand for questions. Thank you. Thank you, Chair.
And I know it was a lengthy presentation, but it needed to be that way. There is no other way to engage in this. I do appreciate you taking the time to put this together for the committee. With that, we'll open it up for questions. Senator Daley, please.
Thank you, Mr. Chair. And thank you for the presentation. It was helpful. So I think you had it in one of your slides, and sorry if the question is redundant. So how many boards and commissions are currently running a surplus versus a deficit? And I think you had it in one of the slides, but.
Chris Sanchez for the record. Thank you for the question. We do have that here. Sorry, I just have to get to the slide. So 2024, the 32 boards that reported, 16 boards have expenditures that exceed revenue, which is about, well, it's 50%.
50-50 basically.
Yeah.
So when they merge together, how are existing liability is gonna be handled. One board had a deficit, another board had a surplus. It seems to me that you, almost like an adverse selection, and say, hey, you know, this group is paying for another group, right? How do you plan to handle that?
Chris Sanchez, for the record, it's one of the reasons why we are going to take 2 years for implementation, because we have to do work with the boards. It's one of the reasons why we've required them to submit their P&Ls now, so we can get full transparency into their accounts and how they're budgeting. Keep in mind that some of this will be addressed because some of the deficits are, thank God, are not large. They may be able to be addressed as we, for instance, remove an IT contract or cancel a website contract. As we start to really dig in and change what their expenditures look like, we may be able to close that gap. In most cases, I think we will, because these gaps are very small. There's not many that have, exorbitant. There's a few, but not many. In the cases where they are rather large, we're going to have some work to do, and we're going to have to, in our implementation plan, delay those boards out a ways in the merger to make sure that we can get their finances cleaned up and on track, so that when comes time to do the merger, they're ready to merge, and we don't have that instance that you described where we have, Board A making up the deficit for Board B.
And different question, and I know you explained it, the dominance, and you mentioned the antitrust. How do those two things work together? And I know you mentioned it, but I'm not sure I got all of it. So the dominance, I think I understood where, the professionals in that board are the majority of who's overseeing it. But I'm not sure why that is such a bad thing, or maybe you can explain further. And then where did the antitrust come in?
Thank you. So that originated from the 2014 Supreme Court case, which was the North Carolina Board of Dental Examiners versus the Federal Trade Commission. In that case, the court decided, in review of that board, that, as you just articulated, that when you have a board where the quorum is reached, incorporates the majority of those folks that are licensed by that board, there's potential for antitrust. But the case also, the court went into and described the differences in supervision and how a state would supervise a board that could mitigate that concern. And so as we looked at this, because as we consulted different lawyers throughout the state, we couldn't really get a solid answer, like, did we fully mitigate this risk as it currently sits with respect to 431? And so what we did is we kind of approached it from both sides. So we, as Nikki went over with the percentages and the reduction and the changing of the makeup of the boards, and then with the reforms that are in 78 on the oversight side, we now have a 1-2 punch, so to speak. So we've addressed both issues that the court reached in their conclusion, which is making sure the state has adequate supervision over the board as it's adjudicating cases and doing its business. And then on the makeup of the board side, making sure that we don't have, like in some cases, we have 90% of the board members themselves are licensed by the board on which they sit.
And then, and you just mentioned the adjudication part on some of the stuff. So I know you had mentioned administrative law judges and hearings. Is that going to be part of, like you're going to have one website vendor for all, however, you're going to end up with 18 or whatever boards you're going to end up with if it goes through. So it seems to me, though, that if I'm a licensed whatever, and I'm going to go in front of people on a disciplinary thing, I need to be in front of peers. How are you going to handle that? Or is it just going to go to an administrative law judge who may or may not know your profession? It seems to me that wasn't clear on how that was going to work.
Chris Sanchez, for the record, thank you for that question. Good question. So keep in mind that for the majority of our boards that already have their current legal counsel in-house, that will stay the same. So if you think of the contractors board, med board, boards like that, their staff structure, those attorneys, those folks that are experts in those professions are going to stay with those boards. But we do have a number of smaller boards where they may hear a case once a year. They may not hear a case at all. And in the instance that a case comes up and they are part of now a merge board, we do have that merge board member that's on that board that has the expertise. And then that board, if they need to, can contract for additional services for that instance to adjudicate that case. not all of our boards are hearing cases. In fact, we have many boards that just don't have cases that come forward. They don't receive, which is good for them, they don't receive a lot of complaints, which is great. So it just depends on the volume of those cases, whether or not they would use the in-house ALJs. And our ALJs will be there in support of the boards. Should there for whatever reason, the caseload increase and they need help, they'll provide additional support. It's not meant to supplant the experts in the boards that currently are serving those boards.
I mean, if I'm going in and I'm gonna be subject to some disciplinary procedure for some violation of what the rule is and various things, I wanna make sure that somebody who actually works in that business and knows whether or not I don't know, took the x-ray right or whatever, in order to make that judgment, not some member of the public. And I understand the dominance and the antitrust part of that, trying to comply with the court case, but I think it waters some of it down a little bit. So I'm looking, administrative law judge may or may not be the answer. I don't know if you're gonna have full-time hearing officers, but then they're gonna be spread out over several boards. I think you're diluting some of the expertise that you might need to have, especially for a peer-to-peer type thing.
Chris Sanchez for the record, and I don't know that there was a question in the last part, there was more of a statement, but we went through and tracked and looked at the number of inquiries a board gets, the number of cases that they adjudicate, and so the staffing model we built is based on the numbers that the board's provided. I hope that they're accurate. And so that's how that staffing model came to be. And we will, as I mentioned kind of at the beginning of the hearing, we will retain staff that are experts in those fields. And we're mindful of what you bring up, and many of the boards have voiced that concern themselves as we've been going through kind of modeling this out and making this reform. And so they know who those experts are. In some cases, it could be an executive director. In some cases, it may be that they have an attorney that they contract with. It could be that it's a board that has substantial staff, and we need to make sure that those folks are part of the new board structure so we don't lose that institutional memory and we don't lose that capacity. I'm doing everything that I can do to make this additive, not deductive. So we won't sacrifice that expertise or the ability of boards to deliver service. I mean, the worst case for me is to go in and try to do this and then get into implementation phase and screw it all up and mess everything up for the licensees. That cannot happen. So we have to do everything that we possibly can in the implementation phase to be thoughtful and deliberate and strategic with those changes that we are making to ultimately protect the general public and ensure that their voice can be heard and that they get the service that they are seeking to achieve.
Members, additional questions? We'll go to Vice Chair Orenshaw, please.
Thank you, Chair, and thank you, Director, and your staff for the presentation. A couple of questions I have. I'm concerned about whether having, practitioners from different professions could lead to conflict on some of these boards. I look at the Section 89, the Nevada Board of Healing and Rehabilitative Practice. I think it's going to be Nevada Board of Rehabilitative Practice and Therapy. I'm wondering what if they, you've got 2 physical therapists, you have 2 athletic trainers, and let's say there is discipline over someone, over a procedure that maybe the physical therapists feel is best practices, but the athletic trainers don't agree with. I'm wondering if there might be conflict having this hybridized board. I see the same possible concern with that advisory committee on Oriental and homeopathic medicine. And what if there's something that maybe the practitioners of Oriental medicine feel is best practices, but the homeopathic physicians don't agree with? I just wonder how you see those conflicts being resolved, where there might be differences between the 2 different professions and what they see as best practices.
Well, Chris Sanchez for the record. Fortunately for us, I mean, like I said, we're not pulling these board mergers out of a hat. Every board merger that we have proposed has existed in multiple states, and so they have a track record. They've reconciled these challenges. They've addressed these challenges, and so there's guidance to be found in those board mergers across the various states that are already in existence and a historical record that we can consult. Ultimately, I think the way I look at this is that, I know that there are those disagreements and that this is a new structure. And so we're coming at it from the framework of the existing structure. And I'm asking everybody to think about something in a new context. I get that, a new paradigm. But I'm hopeful that the professionals that serve on these boards will be able to have a conversation and come to some level of agreement. I mean, that, after all, is what they do, even in their current, in the board structure. There's not always an agreement across the boards. And so, you know, it's hard for me to answer hypotheticals about what may happen in the future because I don't know. But, you know, all I can say is that the one thing that we would have in this reform that we don't have now is that the Department of Business and Industry, through Nikki's division, can step in and help with some guidance in when those instances do occur. So there is some oversight that does not currently exist. So if there was a case that came up where the boards were really just at an impasse, we would be able to bring in business and industry and help solve that problem.
Thank you, Director. And brief follow-up, Mr. Chair.
Please continue.
Thank you. Another question I have on Section 86, the Board of Medical Examiners. I see it's going to have 4 licensed MDs, 2 doctors of osteopathy, 1 physician assistant, 1 respiratory care practitioner, 2 chiropractic physicians, 1 podiatrist, 1 general public member, 1 member representing indigent or uninsured healthcare interests. And I wonder why, in terms of the population of that board, why 4 MDs, 2 DOs, 2 chiropractors? Why that in that proportion? And also, would this board be supervising chiropractors and podiatrists, respiratory care practitioners, physician's assistants, or just MDs and DOs under Section 86?
Nikki Haig for the record. So in looking at this particular board merge, we did look at the complaints that each one of these particular independent boards looked at. That's one thing that we looked at. And it also, we looked 3 things that we looked at on this particular one. The complaints that they had, the cases that they had, and the total licenses that each one of these members have. So the MDs currently have 29,000 licensees. Osteopathic has a little over 3,000 licensees. Chiropractors have a little over 1,000, and podiatrists have 206. So the MDs, we did give 4 seats to on that one because they do have the majority of the complaints, cases, and licensees. Osteopathic, they had 154 complaints, they had 132 cases, they had 3,418 licensees. So we looked at a lot of those different things. In the research that I did, there are 37 states that do combine MDs and DO boards together. There are additional boards that do have at least 3 of the 4 professions. Chiropractors are really the only ones that aren't in a lot of the different professions or a lot of the different states, but it does happen in Virginia and Kansas, Alaska, Illinois, Hawaii, Louisiana, Mississippi, Montana, New Jersey, New Mexico, Ohio, and Oregon. All of those have MDs, DOs, and the podiatrists all on a merge board. All 4 professions, or all 3 of the 4 professions on a merge board currently.
Thank you very much, Ms. Hagan. Chair, one quick follow-up. Then, if this bill passes with the amendment proposed in Section 86, then this Board of Medical Examiners will have, 4 MDs, 2 DOs, the podiatrist, respiratory care. It'll be majority non-chiropractors, but they will be deciding on if, let's say, someone says a chiropractor, committed some offense where they should be suspended or have their license taken. It'll be majority non-chiropractors deciding if a chiropractor might be disciplined or lose their license.
Chris Sanchez for the record. Yeah, this goes back to the staff example that I was giving earlier, to making sure that we have the experts on the merge board that can help advise the board on and make recommendations on the appropriate course of action.
I appreciate that. I just wonder about their familiarity with that healing art and knowing the ins and outs of what I guess is best practices or not. I guess that's just my concern. But thank you, Director.
Chris Sanchez for the record, and thank you. You actually jogged my memory. So this system that we've devised, we know is not perfect. I need to start by saying that. Secondly, we've talked to all the boards, their board chairs and their executive directors. In a lot of cases, we don't agree, but I think it's important to recognize that you know, there's different models of board mergers that exist across the country. So one of them is a super board. It's something that's often referred, you'll hear about in popular discourse, super boards. And that model, as we started to get into conversations with the boards, didn't seem that it would have any support at all, because it takes like this example, podiatry and chiropractic. They would be advisory advisory boards to the main board with no voting member. And so in a lot of our conversations, that wasn't acceptable to the industries. They wanted to have that voting member on the board. So, you know, we are happy to, as this process continues in the legislature, continue to talk about this. It's something that's been, you know, we've been trying to get the mix right, both the number of individuals on the boards to make sure there's representation. We've had a lot of dialogue over the last 8 months on, is an advisory board acceptable, or do you want a voting member? And many of the boards answered that in different ways. And so we had to kind of look at what exists in other states, what's worked in other states. You know, we've had to do a bit of research to see what we thought would be best. And so based on all those conversations and that engagement, this is currently what we're writing into the amendment now. But again, you know, I know this is an area where there's still a lot of questions, and we're here and happy to engage with folks to continue to work through it.
Thank you. And with your, appreciate Director and Ms. Hagan, Deputy Director, with Section 86, this new medical board, when I go through it, I count 12 members. What do you foresee happening if, let's say, you know, I file a complaint against my chiropractor with the board, and the 4 MDs and the 2 DOs think, yep, no, this was malpractice, this chiropractor should have his license pulled, and the physician assistant, the respiratory care practitioner, the 2 chiropractors, the podiatrist, the general public member, and the member representing indigent uninsured interests say, no, I don't think so, and it's tied 6-6. Then would business and industry step in, or what would happen if there's a tie, or would it just be dismissed?
This is actually a 13-member board.
Okay, well, I miscounted. Well, let's say it does get a tie, though. Let's say there's a member absent. Then what would happen in that scenario?
And just for the record, it's hard for me to answer hypotheticals. I mean, we'll have to come up with a process, a business and industry that anticipates as much as we can, but no level of anticipation is going to mitigate any potential outcome, right, that could happen on a board. So it's hard to sit here before you with any certainty and say it's going to be X, Y, Z without knowing what hypothetical situations could arise. And in this instance, you know, on the off chance that one member is absent and that happens, I mean, I don't know that I can give you, you know, a solid answer just right now off the cuff that would be sufficient.
Okay, thank you, Director. Thank you, Deputy Director.
Hague, for the record, I would also think that in the way that some of these current boards are now, if there is a person that is absent, I'm sure that they do have votes and they have some policy and procedure that they have in place that would help in that tie. So I'm sure I'm sure it has happened in the past that they have had a tie vote.
Thank you, Deputy Director. Thank you, Chair.
Thank you. Members, any additional questions? We'll go back to Senator Daly, please.
Just real quick, and some of the questions that we thought of and a couple of things from my previous line of questions. All of these boards now currently have, most of them, I believe, all have ability to promulgate regulations to go through the regulatory process. So when they do that now, I mean, the board goes forward, they have what they want to try to do. You have experts in that field on then how are we actually going to do this? Do you anticipate some of the same issues we were talking about based on the makeup of the board, that people that aren't in one industry versus the other or license area, they're just going to defer to the 2 people that are on the board that are chiropractors to do chiropractic regulations and say, we don't know enough to know if that's right or not?
Understand, just for the record, keep in mind that the regulatory process is an open process where stakeholders are able to weigh in how those regs are created and made. So, you know, we do this right now with our regulatory agencies within the Department of Business and Industry, and they go through that public process for input. And we would have oversight of that process at the department level to make sure that a good representation of that industry was represented in that process, to make sure that those regs were not just informed by two or 3 or whatever the number may be on that board.
Yes, and I'm fully aware of how the regulatory process works, and legislature gives the executive branch ability to promulgate regulations within the legislative intent and the authority. But it's entirely controlled by that board or the executive side. You have to go to the workshop and then hold a hearing, and yes, you take input from the interested parties, but you're really under no obligation to take any of their suggestions. You can still. But you said one thing there too, that, so where is the regulatory process going to be actually housed? Currently, it's in each board, or is it gonna be Department of Business Industry saying, I'm gonna look over your shoulder on everything that you do? Or the board's actually gonna be able to go forward and make the policies they need to make for their profession?
Chris Sanchez for the record. So it's exactly that. The boards, again, going back to my original statement, we're not superseding any of the authorities that currently exist with the boards. So those authorities will transfer over from the individual board to the merge board. There's no language in the bill that would say that we could, come in and supersede those authorities that are granted. So that would be managed by that board and in a way that board sees fit. But because those boards are already now under business and industry, our ability to just provide advice, we would do that. If we saw that there was a potential where a board wasn't involving stakeholders, we would point that out. But the authorities would be vested in that board, and we've not sought to change that. Those, other than transferring, that authority to the merge board, there's no other language in the statute that, or the amendment that would impact that.
All right, thank you. Members, any questions? Additional questions? I was looking at your slide 11, and I had a few questions regarding specifically, in your slide 11, you have enhance Nevada's economic competitiveness. And I'd like to maybe just go line by line on those 4 points. First, you have procurement and contracting. Can you walk me through, in any one of these mergers, you have 5 boards, 6 boards, 2, whatever amount of boards you're combining. They've already entered into previous contracts. What are we going to do with those contracts that have already been signed with that new board? Are we going to honor them? Are we going to try to dissolve them? Who's going to question it? What's that process going to be like?
Chris Sanchez for the record. Yeah, exactly. So you're right. The boards have their existing contracts. As we move through the implementation phase and we sit down with those boards, we'll identify all the contracts that those boards have. If it's an IT contract or a website contract, for instance, I'm assuming that the contract language that's in those boards is typical of what we would have. I would hope that it is, because they are part of the executive branch, where there's the ability for the board to cancel a contract. Let's just use website, for instance. As we get the website built out in business and industry, and we're able to merge those boards onto the website platform, then the contract that exists for that individual service would then be canceled, and the board would migrate over to that new platform. If it's a contract for instance, an attorney and someone that's supporting the board, that would be the conversation that we have to have during that merge process to determine if that contract needed to continue under the new merge board. But that new entity would be the entity that is having to sign those contracts, because that's a new entity that would be created in statute if this bill were to pass. And so those existing boards would cease to exist, and then the new board would come online, and then those contracts that were intended to carry over to that new board would then have to go through the process of the contracting process to re-enter into those contracts.
And do you foresee scenarios where there's a longer-term agreement for a year, 2 years, 3 years, et cetera? I'm assuming in that scenario, you're going to trigger the clause in that contract where it says we can back out of it. I'm just trying to understand, are we opening ourselves to conversations of litigation now? And this is not just one board, right? Every single board has made too many commitments for us to be able to go individually by one, and I wouldn't want to do that. And that's not the intent of this conversation. I want to just understand it more globally and broadly. There's so many contracts that have been committed to. There's so many vendors, agencies, human beings that are committed to fulfilling those. And so I'm just trying to understand, are we opening ourselves just on that lens alone to potential litigation in almost every single board on just contracts alone, or are we confident? I'm assuming you've gone through that already, and I know I sent you a question regarding this preemptively, but I'm just trying to flesh it out and get a better understanding of it.
Chris answers for the record. Well, I think there's a couple of things there. We would have to work with the Department of Administration on reviewing those contracts first. Because as I said, right now, as it stands, because we don't have complete visibility into everything the boards are doing, I can't tell you that all those contracts have the appropriate clauses in them. I don't know. Because we haven't had oversight and because we haven't had the ability to do that. So we would work with the administration, we would review those contracts of the boards that would be merging, for instance. And, you know, hopefully they would all comport with what the requirements are for state contracting. And then we would have to take them on, you know, case by case and look and make sure we don't have any exposure in that instance. And I think and that's absolutely something we would have to do. I mean, that's part of the due diligence that we'll need for merging these boards. But I don't have like statistics or anything I can give you right now as to what that might look like in terms of the number of contracts and whether or not they have that language.
Sure, and I know in conversations that we had, I don't think I've been a session. I've been in this building a single session where we don't talk about how we have issues with our boards and we need to do something to address it. So I do appreciate the undertaking. I know it's complex, it's not gonna be easy, but obviously these are things that concern me on the other side of it, that if we go this route, are we now all of a sudden gonna be in court just trying to get out of all these contracts? And hopefully we don't discover that they've been making a lot of mistakes. But at the end of the day, that's what we're hoping to also identify. If it's been happening, we need to put an end to it. So it's a double-edged sword, and I get that. Staying on that slide, right in the next bullet point there, it says bill draft request, streamline legislative proposals. In the actual bill itself, I don't know that we've actually seen specifically how you intend to do that. And maybe we just missed it in the amendment, and/or there was something in the original bill. But how do you see that playing out? What language are we going to give in SB 78 to achieve this objective?
For the record, so this particular piece is in the original skeleton bill. I'd have to go through it to find where it's at, what section that it is in. But we do have that section in that they would basically be working with the Office of Boards, Commissions, and Council Standards on those BDRs.
Okay, understood. Because, and again, we would want to just be able to flesh that out so we understand exactly how we're going to achieve this objective respectfully. And this will go back to the questions regarding contracts, but in the phased transition, which is your fourth bullet point there, I'm thinking, and let's just call it new board one, right? I don't want to pick on any one of those. And in that, we're going to put 5 different boards that are in existence now. How do you see the transition phase happening at the moment? So hypothetically, the 5 boards are independently meeting now. They're taking action. Some are meeting weekly, some are meeting monthly, some are meeting whatever that may be. Now we're in the transition phase. At what point will those 5 stop and the new one be the lead? Can you just walk me through how you see that playing out?
Yeah, so Chris answers for the record. So keep in mind that the new board would have the appointees that were appointed by the governor. So it would be, we'd have to make sure that board was operational in terms of the appointments all being done, the board able to meet. And then we would need to work out, so all the boards don't meet all on the same schedule right now. So in whether it's 3 or 4 or 5. And so we would have to work with the boards in terms of their ops tempo and managing that ops tempo and how that transition will be to that new board. So to your point, you know, if they have a reoccurring schedule right now in which they hear cases, we would have to come into that, you know, early on if this were to pass and say, okay, we don't intend to merge your board until, you know, 3 quarters from now. but we need to start looking at planning on how we're going to do that. So we'll look at that ops tempo, we'll look at how they, what their schedule looks like, how the caseload is managed, and we'll start to adjust that so that we know that at that point, we're gonna be ready to transition that function to the new board. You know, there's not gonna be an instance where, you know, we're flipping a switch and everything just shuts off, and then we have to just, you know, and then we have to scurry it around and try to figure out how to set it up on the new merge board. So we will make sure that that merge board can function. Part of that is the staffing that will be within the department in Nikki's division. So there's that support network there that will be in existence to help with that migration over. And then we'll have to, on the other side of the equation, build out that ops tempo for the operationalizing that new board. So those things are gonna have to work together in tandem. It's going to take a lot of planning with those boards. Nothing that we're talking about here can be done with just department staff. This is those boards, their current staff, mapping that out with us, working together as a team, all those boards, not just any one board, but, you know, staying with 5 boards. That's all those 5 boards coming together at the staff level with our staff and mapping out what that's going to look like for that transition to occur, coordinating with all those boards and making sure that their operations are kind of in at the right place for us to do that transition, and then on the and then how that will flow on the other side. So it has to be done through collaboration, has to be done with a lot of communication and a lot of planning, and that's what we envision doing in this process, so that we can ensure that, you know, we don't, to use my earlier analogy, that when we flip that switch on, things still work. But it may mean, for instance, that, because, and remember, not all boards have the same amount of caseload, right? So you, in a 5-member board, you may have one board that maybe hears 2 cases a year, maybe 4 cases a year. You may have one board that hears 50 cases a year. So all that has to be taken into consideration in terms of workload and making sure that we're balancing that out as we go. And that can be done through, I think, the scheduling. It can be done through how we onboard the staff, and then making sure that the department is supporting those functions as we move into that new board.
And then staying on that vein with the trying to transition all this to work, in the scenarios where you identify a particular board has just, and I am not alluding that this exists, but you just find out that there's been an abuse of power, lack of competency, whatever it may be, and do you foresee there being some scenarios where there may be a board where you don't even transition one of those board members to kind of the new structure? Do you see that happening? Or do you really see, we're gonna take all the current board members here, here's the new composition, and we're gonna really wanna be cherry picking from the folk that are already there? Or do you see some new, I'm just trying to understand a little bit of how you see that all kind of playing out.
Yeah, Chris answers for the record. So I'm not involved in the appointment process, but my recommendation would be we have to make sure that we have the institutional history and memory. And so to reconstitute a completely new board with new staff that doesn't have that history or memory would be, I think, problematic. So we need to make sure that as we are standing up those new boards, that we're looking at those existing, you know, let's say there's the 5 boards and 25 members, for instance, right? We need to make sure that there is continuity between the old board and the new board. And so that is something we absolutely would have to take into consideration. And we would be making recommendations, I think, to the governor's office for those appointments in that instance.
Understood, and 1,000%. I think all the legislators could disappear, and this building would be fine if you get new folk, but you cannot get rid of our staff, right? The staff is the institutional knowledge. We absolutely need them. I think you're laughing because you know it's absolutely true. We are nothing without our amazing staff.
Chris Sanchez for the record, and thank you for that, Chair. I mean, I was alluding to the appointees, but absolutely. I mean, that is one of my chief concerns here is we have, not an exaggeration, we have staff in these boards, but for those staff, the board wouldn't work. Those folks have to stay employed with you know, whether the department or in the new board structure. And they've already become known to us in this process. And when we've had folks come in and say, you know, absolutely, you know, we need these 3 people. I mean, without these 3 people, we just can't do this job. And keep in mind, too, I mentioned there's 318 staff. We're going to be bringing on about 70 at business and industry. So there's a majority of the staff is staying with the boards, and it will be migrating over to the new board. So we agree. I mean, that's essential for this to work.
And this is just for my knowledge, because I don't know. Are the staff, are they mostly unclassified, or are they or is it a hybrid, classified and unclassified? Do you know?
Chris Sanchez for the record. I'll have to follow up to the committee with the breakdown, because I don't know the numbers off the top of my head.
Fair. In the instances where they are classified, those are the ones that probably we're most concerned about, ensuring that whatever collective bargaining agreements are in place, are we going to honor that? Are we looking to change some from classified to unclassified? Obviously, we wouldn't be able to do that. So could you walk me through that, please?
Chris Sanchez for the record. Thank you. Good question. Absolutely, we'll honor all those commitments. There's no intent on our end to change that status, or, it would, when we move them into the agency, majority of our staff are classified staff. If they were going to go look for a job in another agency, I mean, we would work with them to make sure that held true in that transition.
And then lastly, and we are igniting some additional questions, so this is good. And I will hog the mic for one more, and then I'll send it back. In that, specifically on the classified side, just opening my memory now to another point that I wanted to address before that I forgot to get on the record. In the scenario that we do have clauses where three boards, let's just say something very innocently, IT. Three boards have IT clauses that the contract follows any superseding contract that were to occur. How do we want to approach that? Do we have a game plan there?
Chris Sanchez for the record. I can give you an answer off the cuff, but it's one of those things I need to consult administration and probably the AG's office and make sure we get it right. I mean, throughout this process, we're very, very diligent in what we do. And so nothing's just going to be on a whim. I mean, again, we'd have to go back, do those contract reviews. We'd have to see where they stand and what those clauses are or are not, and then develop a plan based on that. But that would be in consult with administration, in consult with, where applicable, the AG's office, and making sure that we do that correctly, however correctly is defined based on what we find when we do the research of the contracts. Hopefully that is sufficient for now based on what we know.
Yes, please.
Nikki Hague for the record, and we do have that in the amendment, number 3 in the amendment. We do address the contracting with state purchasing and the Attorney General's office.
And I will look at that right now as I hand it over to Senator Daley, please.
Thank you, Mr. Chair, and I was thinking of a couple of questions. So I'm looking at this document here. You guys have this one? Yeah. And then, and I think it's along the lines of what he was saying, so it's on the next to last page, under staffing and administration, sub 3. Is that the one you were just talking about? Yeah. So tell me, so it says, where a contract is validly entered into and does not have appropriate termination without cause language for use by the department, this language, I'm not sure what language you're talking about, this language or some amendment that's going to end in the bill, shall operate as a non-appropriation for the existing contract. Does that mean you're just not going to pay? That's the way I read it. I can read English, but constitutes a non-appropriation, so the way I read that is you're just not going to pay.
Good evening, Homa Sayar, H-O-M-A, last name S-A-Y-Y-A-R, General Counsel for the State Purchasing Division of the Department of Administration. Just to take a step back on kind of the contract structure questions. Our boards and commissions have to comply with NRS Chapter 333. What we've found in a lot of our research is that many of them don't. So if we are finding contracts that do not have our state standard terms, there are issues there. And NRS 333.810 provides that where an executive branch or using agency doesn't comply with all of Chapter 333, the person who signed that contract now has a contract. And the administrator or their executive director also has a contract, but the state doesn't. And so that's really important to highlight that when these boards and commissions are entering into contracts, they are using the proper processes. They're following the state administrative manual. They're using a certified contract manager within their entity. They're being trained, they're being supervised. We find a lot of rogue contracts with really stringent terms that don't give term for convenience, that don't have term for non-appropriation. So to your question about, are we just going to use termination for non-appropriation to, leave people high and dry? I always say that the state is a fantastic contractual partner. We pay our bills, we pay for work done. We're not trying to take something that isn't due, but a lot of these contracts contain terms that are not appropriate. For example, interest, penalties, renewal clauses, things that are anti-competitive. And really, it would be against the concept of reform to turn around and endorse those terms that business and industry is actually trying to break down. So they're seeking tools to be able to get out of contracts that are inappropriate.
Understood, and I have a bill on that very subject, trying to tighten up some of that non-competitive stuff. Hopefully it'll get through and we'll see that. So my second question, and I was just reading that language and saying, all right, what does it mean? And I know there's some technicalities on some stuff, but just not paying, basically it's a non-appropriation. We're gonna take the money back and we're not authorized to spend it anymore is the way I read it, but,
If I may, Senator Homosayar, for the record, I think that when we are using non-appropriation arguments strategically, when we're dealing with goes back to the chair's question about, are we opening up to litigation? That's your last ditch argument, right? Which you get there through, settlement. A lot of vendors, when we do have contract disputes, I used to be at the Attorney General's office, we've dealt with a lot of contract disputes. When the state pushes back and says, let's talk about what actually was done so that we can pay you for your work and we can part ways. There's really should never be an expectation that you're owed payment for work that hasn't been performed yet. And so that's where the non-appropriation concept comes in. You're not trying to fail to pay a bill that's owed. You're actually just trying to deal with the expectation. So for example, there was a remark about what about the length of these contracts? Under the state administrative manual right now, it's recommended that no contract run more than 4 years. We don't know if that's happening with some of these boards. With the surveys that we've done to the boards, many of them didn't disclose any contracts, and we know they have contracts. So we were trying to get that information and trying to help, plan for this. But a lot of this will come through the iterative process that Director Sanchez mentioned.
Understood, and I know there's a recommendation on 4, there's longer contracts, and then there's built into those contracts renewals and extensions, so there's an anticipated term on some of that. But if someone just has their contract and unbeknownst to them, whoever was doing it didn't do it properly, and they're expecting that, maybe not paid for services they haven't performed, but they're expecting a 3 or 4 year or longer contract to provide those services, and now they can be pulled out. I think that was the question our chair was asking, but, and if, as a policy person on this side of the dais, what authority are we giving and granting? And we need to know exactly what that means and how it's gonna be done. And is it something we're comfortable with, right? Or do we need to have, a little less, we can just non-appropriate, on that, so go ahead.
Thank you, Homosayar, for the record. Obviously, I exist in the state form quite a bit, but there's a section in the state form already that talks about intervening bienniums, right? So it says that an intervening biennium is deemed as this kind of continuation because the legislature correctly controls the purse strings and the authority on some of these expenditures. So we're already kind of existing in a fictional world where we're saying that we're renewing, but we're not really renewing.
Understood, you can't go past the 2-year budget because no legislature can bind the next one to anything, I understand. So switching gears, unless you had.
Thank you, Senator. I do. Chris Sanchez, I just want to say, we're not seeking any additional authorities. We're just simply trying to bring the boards into the fold, so to speak, so that we, under our current operational authorities that we have as a department and overseeing our agencies that we have, that these boards be brought into that fold and we will exercise the existing authorities that we have as it pertains to state contracts.
Thank you. So switching gears. So the one question that our chair had on the bill draft request, I believe that's in section 13. And I am trying to figure out where you say, hey, we're not asking for more. So when I get down to the subsection B, 2B, so if a board, commission, council, or seminal body is authorized non-legislative requester entitled to submit the request for drafting. So some of these boards have been given bill drafts by the legislature, so they're okay and they can still go by. How were the other ones that weren't given specific bill drafts? What's the process now for them to put a bill forward? Who do they gotta check with? Because the way I read this is, before they can do it, they gotta go on and go before the king and ask permission and say, you know, my family's hungry, I need some more sheep.
Sanchez for the record. So currently, they have to go and find a bill sponsor for, and, you know, their policy reform. I would need to get back to the committee on which of the occupational licensing boards are actually granted BDRs in statute. I have that list, but don't remember seeing any Title 54 boards on that.
No Title 54.
So some of the advisory boards, that is true, but we're amending those out of this reform. So that would be applicable in that instance. But none of the Title 54 boards have statutorily authorized BDRs.
So they're able to go to a legislator and say, hey, I want to do this change, and if they want to do that, then obviously they could. I know I have a bill on the court reporters board. Probably upset your new deal because we're adding a new person to the board, but nevertheless. But the way I read this is they wouldn't be able to do that.
So Chris Sanchez for the record. I think this is an area that we can look at in terms of cleaning up the language. The intent is not to be Big Brother, so to speak, but we do want to have visibility into what the boards are doing, whereas right now there just is none, frankly. So we want to be able to see, hey, we're going to go, we have, you know, these issues we need to solve for, and we're going to go do that, and you know, we need to be able to have visibility to that. But the intent is not to say, kind of as you characterize it, you know, no, you're not going to do that sort of thing.
And I agree, you need to go back and look at it, because the first sentence there says, a board, commission, council, or similar body under the purview of the office pursuant to NRS 232-8415 may not request any person or government entity submit to the legislative council a request for the drafting of a legislative measure on behalf of the board or commission, council, or similar body other than is set forth in this section. I'm saying, they can't even come and ask me. Last I checked, you guys can't stop me from putting a bill draft in if I'd like. At least last time I checked. I mean, and if one of the boards or commissions wanted to come and ask and I wanted to put one in, would they run afoul of that language that I just read?
Chris Sanchez for the record. As it's currently written, yes, I think your conclusion would be accurate, but that's not what our intent is. But I think this is probably one of those instances where the skeleton draft was doing us a disservice and not having full draft language. But it's not what we intended, and we're happy to work with the committee and on revised language for that.
And just for clarification, I never blame LCB staff or anybody for bill drafting errors. I failed to communicate what my intent was.
I take that under advice.
So I think that's, never blame the staff.
Senator Daley knows better. He doesn't want to get hurt. Heidi runs a tight ship over here. Ms. Clarkson is amazing. Members, any additional questions? If I could, on the merger side, when we're kind of seeing this play out, on the educational side, I understand how we're going to do it here. You're going to be working individually with the boards diligently. How do we educate the public? Are we doing this in different languages? How are we marketing it? What's the game plan on just educating the community on how this is going to work so that we're all on the same page?
Chris Sanchez for the record, thank you for that question. We have requested budget enhancements we're adding 2 PIO staff. We've asked to add 2 PIO staff to the agency, support staff, as well as we've made a request, is it 88,000? I can't remember the number. It's not quite 100,000. I can follow with the committee with the actual request for marketing so that we'll be able to get the word out. So we are enhancing staff with expertise in social media as well as on the overall ability to market. And then our agency has received additional support funding for translation to make sure that we're able to get the information out in multiple languages. So I think it was a ARPA grant. I apologize, Chair, I don't have everything right at my fingertips here, but actually we have, it's Marcel. Marcel, are you out there? Phone a friend, Marcel, are you out there in the south? Yes, Marcel's there. Putting you on the spot, Marcel, but if you can talk through a little bit of the translation and the grant that we've got, that would be helpful. Thank you.
Marcel Scherer for the record. Under the Language Access Plan, we have a robust approach to translate what is called vital documents, and that will be another way that we can educate the community. All the individuals who may not understand the language of commerce, English in this case. So we have a robust approach to be able to do that right now.
And thank you for coming up. Question to that. You're eligible for federal funds under the Safe Streets Act, if I'm not mistaken, to cover those expenses, right? The state wouldn't be on the hook for vital translation of vital documents?
Well, within our, Marcel Scherer for the record, Senator Flores, we are looking at what this, within each of the divisions, what we can do regarding our own forms and our own translations. I don't know specifically beyond June 30th of this year what we'll be able to do or not do regarding some of the translation services.
Chris Sanchez for the record. I was not aware of there was funding available through that program, so we'll look into that to see what we might be able to apply for.
Please, it's my understanding that by federal law, we are now required to translate vital documents, and that state agencies or whoever they're doing, you can apply for that funding. I know the Secretary of State in a previous session had helped me kind of identify how that stream of money was going, and it went into the conversation of how Nevada often leaves money on the table because we just don't apply for it, and or a lot of folks just aren't aware that we're required by federal law to comply, but luckily federal government funds it, right? And but you have to apply for it and tell them what you're doing and what the expense looks like. Question regarding the when we were discussing the game plan of implementation with the boards. It is not your intent that at any point we have a board A through D who are going to now become merger board 1. There's no scenario where you anticipate the merger board 1 to be existing simultaneously as boards A through D, correct? There's not going to be a scenario where these 4 are operating, and as you're slowly trying to transition into the merger, that one's operating also.
I'm sorry, Chris Sanchez for the record, yes. However, and all this goes back to the planning that I kind of articulated earlier. We have to make sure that these boards are ready to transition. So they can't just be, we turn these off, turn that on, and then hope it works. So there's going to be a process that we have to work through to make that work.
Perfect, and I appreciate that. I just want to make sure that there wasn't ever going to be a conflict where you're not. These are existing while the merger is also simultaneously, and fair. And I just wanted to get that on the record. Members, any additional questions? Seeing none, I do want to say thank you for joining us into the late hours. We call it government affairs after hours. I really do appreciate the hard work you put into the presentation and engaging in the conversations. Thank you very much.
Thank you, Chair, and thank you, Committee. Appreciate it.
I'd like to invite you to sit back. And at this time, I'd like to invite those wishing to testify in support of Senate Bill 78. If you could please come forward, either in Carson City or Las Vegas. We do see some folk in Las Vegas, and I see some folk coming forward in Carson City. We'll start with Las Vegas, and then we'll make our way back to Carson City. In Las Vegas, whoever wishes to go first, welcome.
Good evening, Chair Flores and members of the Senate Governor Affairs Committee. My name is Maureen Schaefer, and I am the Executive Director for the Council for a Better Nevada. I am here testifying in support of SB 78, the Nevada Office of Boards, Commissions, and Councils Standards, and the Governor's Office of Business and Industry was established by the passage of Senate Bill 431 during the 2023 legislative session to better align these entities with Nevada's workforce and economic development goals. The council supported the passage of SB 431 after listening to countless public officials and citizens over the years serving in roles struggling with governance and needing services to perform their obligations. We repeatedly heard the need to modernize to elevate outcomes for citizens serving in government and citizens receiving government services. SB 78 will be the next success of your successful passage of SB 431. The Lindsay Institute, with Michael Brown to my left, together with the Council for a Better Nevada, is now tracking 37 pieces of legislation or budget proposals this session that represent additional modernization ideas of state government. We have screened legislation using this test, and my colleague has the same mission. Government modernization is a process to reimagine and transform Nevada's and its workforce's performance by updating and improving processes, systems, or services, and incorporating continuous improvement, transparency, and innovation into operations. SB 78 is at the top of that priority list and meets this definition with improved transparency and accountability of state boards and commissions, reduced administrative costs and redundancy, innovation and service delivery, enhancement of Nevada's economic competitiveness, and compliance with federal antitrust obligations. We want to thank Director Sanchez and his incredible team for bringing this bill forward with the intense work and commitment over the last 2 years. And we ask for your support for the continued modernization of Nevada's government. Please support SB 78. Thank you.
Thank you for joining us. I do see one more individual in Las Vegas. We'll go to Las Vegas and then we'll come back to Carson.
Thank you. Mr. Chairman, honorable members, my name is Michael Brown. I am a fellow at the Lindsay Institute, an independent think tank at UNLV, working in partnership with Brookings Mountain West on issues of government modernization and efficiency. It was also my honor to serve 4 years in the Sisolak administration as director, first as the Department of Business and Industry, executive director of GOED, and an unexpected collateral assignment on the governor's pandemic response team during the public health emergency. I have had the opportunity over the last 18 months as an academic fellow to look at efforts to modernize Nevada state government in 1924, 1948, 1963, 1993, 2008, and 2023. In fact, I found that the 1924 study in the state archives and was able to retrieve another portion of it from the main library at Harvard University that Director Sanchez referenced. This was on my desk when I arrived at BNI as director. The Governor Sandoval Audit Division had left recommendations for improving the management of boards and commissions. Deputy Director Reynolds and I attempted to tackle that in the summer of 19. I went up and visited the Department of Commerce in Utah and saw an amazingly efficient division of occupational licensing that was clearly 21st century, while we were still, unfortunately, hearkening back to parts of the 19th century. I was moved over to GOED, but that didn't end my engagement with BNI. Director Reynolds consulted me, but Director Reynolds then brought forward the proposal that was incorporated in SB 431, which was probably the most landmark modernization bill in recent, in 100 years, frankly. BNI was structured much the same way. BNI was originally created as a Department of Commerce, where they took an old regulator of insurance and finance and real estate, and they brought it all together. And as director of BNI, your job's really there to make sure that the public processes are followed and that we follow the records. And I think, Mr. Chairman, I've submitted a longer statement and would be glad to answer any questions on this. I think this is a terrific piece of legislation, and frankly, looking at all the modernization initiatives, I have never seen a package like the 47 slides of Director Sanchez's presentation, and his department should be commended for the incredible work that they've done on this proposal.
And thank you. And I did let you go a little bit over because I thought you were about to hit the final point. I do want to remind folk that we are going to be capping folk at 2 minutes. We always do that. It's not unique to today. If you have a much longer statement, I want to remind you to please email that to us so we can get the full breadth of your concerns, of your support, of your neutrality, whatever it may be. But we are going to be limiting folk to 2 minutes. Thank you again for joining us from
Thank
Las
you.
Vegas, and have a wonderful evening. We'll come back to Carson City. Whoever wishes to go first.
Good evening, Chair, members of the committee. Paul Maratka with the Vegas Chamber. First, Chamber would like to acknowledge and appreciate the work done by the Department of Business Industry, and the Chamber supports the premise of the bill and the amendment that's been proposed by B&I in relation to Senate Bill 78. The Chamber supports the amended bill because it modernizes the boards, increases efficiencies, streamlines operations, and brings greater transparency and oversight. These are principles the Chamber has advocated for years in this bill when it comes to government. We recognize there are a lot of changes proposed in Senate Bill 78 and the overhaul that the existing structure would occur if the bill moves forward. But as an organization that represents many sectors of Nevada's economy, the Chamber welcomes the discussion that is occurring because of this bill. It's important to have the conversation to see what is working and what is not working for Nevada and its industries, to adopt practices that are working and identifying those that may need updates or changes from a government's perspective. And that, Mr. Chairman, is why the Chamber does support Senate Bill 78. And again, appreciate the effort today in those conversations. Thank you very much.
And thank you for joining us this evening. Whoever wishes to go next.
Good evening, Senator Brian Walker, Senior Vice President of the Retail Association of Nevada. We will echo the comments of the Las Vegas Chamber of Commerce. You know, in our experience, we have had difficulty and some frustrating making sure that the boards are all following the correct procedure, making sure that they're following the Administrative Procedure Act. And we oftentimes get boards who aren't maybe in the spotlight a lot, who sometimes aren't following those correct guidelines. And so it makes it difficult, especially as an association, to make sure that we are making sure our members are up to speed, informed, so that they can make those decisions and they can be active members of their licensing community. And so for those reasons that we are in favor of SB 78, and we look forward to the savings and the modernization from the plan.
Thank you. Good afternoon. Welcome.
Good afternoon. Isaac Tenorio with Strategy 360, today representing the Nevada Speech Language Pathology and Audiology and Hearing Aid Dispensing Board. Our board supports this bill. We want to thank Dr. Sanchez for his cooperation throughout this extensive process, and we urge the committee to support this bill. Thank you.
And thank you. Anyone else wishing to come forward in Carson City or Las Vegas? Seeing none, in BPS, we will go to the phone line. Those wishing to testify in support of Senate Bill 78.
If you would like to testify in support of Senate Bill 78, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 505, please press star 6 to unmute yourself. Caller with the last 3 digits, thank you, please continue.
Hi, my name is Peter Guzman, President of the Latin Chamber of Commerce. We will be submitting a much longer support letter, but in respect of everybody's time, we certainly wanted to say that we are in full support of SB 78 and the modernization that this will create. I also want to commend wholeheartedly Director Chris Sanchez and his amazing team for not only working hard for this bill, but allowing input, sitting down over and over again, discussing things with all of us stakeholders in the community, and being just really thoughtful and responsible in getting to the place that we're at today. I could go on and on, but I just want to commend Chris Sanchez and the team for getting us to this place now. This is hard work, a long road, and the Latin Chamber of Commerce, with all of its members, supports the direction that this is going, and we will stand with you in full support of it. Thank you so much.
And thank you for joining us this evening. Next caller in support of Senate Bill 78.
For the record, my name is Attar Hasibullah.
Go ahead.
Sorry. For the record, my name is Attar Hasibullah, first name spelled Athar, last name Hasseebullah. I'm the executive director for the American Civil Liberties Union of Nevada and a civil rights attorney by background. We're testifying in support of this bill as amended, and do want to thank the Department of Business and Industry and Director Sanchez for taking time to brief us on this bill and to include us in the process, as well as Counsel for a Better Nevada, Maureen Schaefer, and the work that was led by her, Michael Brown, and others over the course of the years. Obviously, as previous Director Brown had testified, this has been an ongoing process for modernization for a number of years, starting under the Sisolak administration. From our vantage point, the lack of transparency and accountability within existing boards poses significant civil liberties and civil rights related issues. We're happy to support this bill as amended, and we look forward and hoping to see it through to better the lives of ordinary Nevadans. Thank you.
And thank you for joining us this evening. Next caller in support of Senate Bill 78, please.
Good evening. My name is Brittany Backoffen, BRITTANY for the record, and I am the president of the Nevada Athletic Trainers Association. We are the professional organization representing athletic trainers in the state of Nevada. I do not speak for our licensing board. I am here to represent the interests of the athletic training community and our patients at large. And this includes patients from our professional sports organizations, all the way down to those working on the front lines with our high school student athletes and those that come to Nevada from other states to play in various travel sports. Our organization supports SB 78 as described with the Nevada Board of Healing and Rehabilitative Practice as amended today for the athletic trainers. I just want to express my appreciation for Mr. Sanchez and Ms. Haig collaborating with us on the amendment to this bill. I would like to really express my appreciation to the senators on this committee for asking questions and sharing the same concerns that we have voiced. Yeah, thank you very much. I appreciate it.
And thank you for joining us. Next caller in support of Senate Bill 78, please.
If you recently joined us, we are currently in support of Senate Bill 78. If you would like to testify in support, please press *9 now or raise hand in your Zoom window. Chair, you have no more callers in support at this time.
And thank you. I wanted to make sure we didn't miss anybody in person wishing to testify in support. Seeing no one else coming forward. At this time, we'd like to move into opposition for Senate Bill 78 in Carson City or Las Vegas. I see a few folk here in Carson City, and I think in Las Vegas we only have 2. So what we'll do is we'll start with Las Vegas, and then we'll move back down to Carson City. Whoever wishes to go first in Las Vegas. Good evening and welcome.
Thank you, Chair. Members of the committee, thank you for the opportunity to speak today. My name is Jennifer Letton, and I am the president of the Nevada Board of Dispensing Opticians. I'm here today on behalf of the board to express strong opposition to SB 78, which proposes merging our board with the Board of Optometry under a 3-2 structure favoring optometrists. This bill threatens the independence and professional integrity of both fields. Optometrists and opticians have very different scopes of practice, educational pathways, and responsibilities to the public. While optometrists diagnose and treat medical eye conditions, opticians specialize in the technical fabrication and dispensing of medical devices such as prescription eyeglasses and contact lenses. These professions are distinct and require oversight by experts within their own discipline. SB 78 would result in opticians having a vote on matters of optometric misconduct and vice versa. That is highly inappropriate and sets a dangerous precedent. Professionals should not be asked to regulate areas in which they have no training or authority. This cross-regulation invites confusion, undermines accountability, and risks unfair and uninformed disciplinary decisions. Our current board of dispensing opticians is self-funded, transparent, and effective. There is no evidence of inefficiency or failure to justify this merger. Instead of solving a problem, SB 78 introduces new risks and dilutes professional standards. On behalf of the board, I urge you to reject SB 78 and preserve the autonomy and integrity of each profession's regulatory body. Thank you.
Thank you for joining us this evening. Next speaker in Las Vegas.
Good evening, Chair Flores, members of the committee. My name is Joelle McNutt, and I'm the Executive Director for the Nevada Board of Examiners for Marriage and Family Therapists, Clinical Professional Counselors. And we, as a board, want to oppose this bill for some of the reasons that were brought up as questions from committee members earlier, and much to what my colleague here said. We're concerned with protection of the public, also with the combination of the boards. We're concerned with nuances with scope of practice, ethical codes between the professions, and also how disciplinary action will be enforced. And with that, the appropriate stakeholders won't have a seat on that board, and they will be in charge of regulating the professions that we govern. Also, there's a concern with the reduction in workforce that would have an adverse effect on our efficiency and response times for the people that need help. And with other pieces of legislation going through right now with the counseling compact that impacts us specifically. I know social work has a compact. Those new systems at work in this new system will potentially have an adverse effect on our efficiency and ability to regulate and issue licenses. Thank you.
And thank you for joining us. Anybody else in Las Vegas? Seeing none, we'll come back to Carson City, whoever wishes to go first.
Good evening. My name is Dawn Echeverry, and I'm the president of the Nevada State Education Association, the voice of educators in Nevada for over 125 years in all 17 counties. NSCA opposes the provisions of SB 78 that water down educator voice on important boards and commissions. The Teacher and Leader Council monitors and makes recommendations regarding educators' performance evaluations that ensure that they are fair, timely, rigorous, and valid. Currently, 4 of the 16 members of the TLC are teachers from Clark, Washoe, Mineral, and Carson City. SB 78 would reduce the number of teachers on the TLC to 1 of 9, watering down the teacher voice while also limiting geographic representation. SB 78 would also eliminate the Nevada State Teacher and Education Support Professional Recruitment and Retention Advisory Task Force, rolling its responsibilities into the Nevada Commission on Innovation, Excellence, and Education Workforce Development. The current task force is comprised of teachers and education support professionals from across the state. AB 78 would water down the focus of the education recruitment and retention, which is one of the most vexing issues facing Nevada. A new commission on innovation would only have 1 classroom teacher and would eliminate the voice of education support professionals entirely. SB 71 passed last session, added the voice of the SPs to this important work. SB 78 also proposes to merge the Commission on Professional Standards in Education and the Statewide Council on Coordination of Regional Training Programs, giving all 9 appointments to the governor. Currently, educator members of COPS and RPDP are nominated by organizations representing educators like NSCA. Eliminating this process further erodes educators' voice. NSCA asks for your opposition to these provisions of SB 78. Thank you.
And thank you for joining us. Next person, please.
Thank you, Mr. Chair. Michael Hillerby on behalf of the American Institute of Architects, Nevada chapter. First, would like to thank Director Sanchez and his staff. They have met with me on multiple occasions to discuss the bill. In the amendment, we did see some improvements in the suggested consolidation of some of the boards. We do still have concerns. Those are specific about lowering the number of architects on the board. We think a wide variety of expertise and specialization is important when they're considering regulations, when they're considering discipline and other matters that affect public safety. So having more than 3 members, a backup to the current 5, probably makes sense. Obviously, the stated purpose of this is efficiency and cost. We think that should always be a goal of state government. I hope there is not a board out there that doesn't welcome oversight, that's not willing to answer questions about their operations. I think the State Board of Architecture, Residential Design, and Registered Interior Design is one of those that would. Just a couple of things about the board, because I've asked for them for some details. They are right now licensing architects to come in from out of state in about 3 days. The architectural registration fee is $180 when you renew your license. That's relatively inexpensive. It's less than probably a number of us pay to register a car. We think our board works well. We have licensing specialists that understand the technicalities and the things they do. We did hear in the presentation that the idea was that hopefully some of those people would stay in those positions. I think there is probably some clarity that's lacking in that language so far to clarify that that is in fact what's going to happen. And I'm probably one of the odd people that finds the market dominance discussion interesting. I would point the committee to a presentation that your own Kevin Powers made in April of 2016 to the interim Sunset Subcommittee. He talked about this in some detail, the North Carolina dental case, how in fact the setup in Nevada is different, that both because you as the legislature passed the laws that describe the duties and responsibilities of the board, the scope of practice of the profession, you approve any regulations that are done, the governor appoints those members and are answerable to him. We think a lot of that information would be helpful in addition to what you've received tonight. I see you nodding. I may be running out of time. Thank you very much. Again, we'll look forward to continuing to work, but we think the current system in many ways works well. Again, where there is additional oversight that's appropriate, there are probably some steps in this that make sense now, but maybe not going as far as the bill contemplates at this time. Thank you.
And thank you for joining us this evening. Whoever wishes to go next.
Good evening, Chair Flores and members of the committee. My name is Victoria Erickson, Erickson, and I'm here to testify in opposition to Senate Bill 78 on behalf of the Nevada Board of Examiners for Social Workers. I am the executive director of that board. SB 78, while well-intentioned, would fundamentally disrupt the integrity of our board's mission and decision-making process and may lead to the termination of its leadership and subject matter experts. The bill suggests that BNI will create increased transparency, accountability, and efficiency, yet nothing has been provided to suggest the actual steps for any of this and the costs associated. In fact, the way the bill is being heard today shows a lack of transparency. While BNI has requested volumes of information about this board, they have provided no feedback to us nor engaged in any meaningful discussion about how each board has been evaluated and the outcome of the evaluation. Comments are made in generalities, when in many cases the comments made do not apply to the social work board. If concerns exist about this board's operations or accountability, we believe that they should be addressed through open dialogue, not unilateral legislative action. This bill threatens the very independence that allows any occupational board to serve the public interest and ensure public safety without undue political influence. If the legislators' concerns is transparency or oversight, we welcome collaboration to improve communication or reporting mechanisms, but SB 78 as currently drafted undermines the fundamental governance structure of our board and could impair our ability to operate effectively in the public interest. For these reasons, I urge this committee to oppose SB 78. Thank you for this opportunity to testify.
Thank you for joining us this evening. Welcome.
Thank you, Mr. Chairman, members of the committee. Alexis Notarex with the Nevada Chapter Associated General Contractors. We too have concerns with SB 78 as it was presented today, in particular the portions affecting the State Contractors Board. We were under the impression, based on early conversations as this bill was being drafted, that no changes were being contemplated for the Contractors Board and thus did not think our members might be impacted. We only saw the summary of the amendment last night and felt like we needed to express our opposition to this change. The Contractors Board is one of the most efficient organizations in the state and self-funded. It should be seen as a model to other boards and not be subject to changes in membership requirements as proposed without their input or per their request. Thank you.
Thank you for joining us. Welcome.
Thank you for letting me have this time tonight to talk. My name is Crystal Roll, last name spelled R-O-L-L. I come from a unique perspective tonight because I am public, I am professional. So I am a proud licensed clinical social worker that serves Nevadans in rural counties. Upon review of this bill, I have a few concerns. I'm all for accountability, transparency, and competitiveness, but I don't see the problem with the social work board. I have concerns about disciplinary action. I don't want folks that are not LCSWs or even LSWs questioning if I put someone on a hold, why I'm doing a certain therapy modality, things of that nature. That's a concern to me. So far as efficiency and funding, I've looked at the social work board website and it's excellent. You can watch the board meetings, they're recorded. You can see their audits. I'm actually trying to apply for a license in another state that's already blended. It is very expensive. It takes 1 to 2 weeks to get a call back. And then in another state, I decided to just give up because I still haven't gotten a call back on a question I have for the application process. So thank you for your time.
Thank you for joining us. Good evening.
Good evening, Chair and Committee. Shelley Capurro, for the record, representing the American Society of Landscape Architects, the Nevada chapter. And they are licensed in all 50 states, and they are integral to outdoor design, including community and defensible spaces. The professional society is opposed to the board consolidation. They feel that their board runs extremely efficiently, and consolidation could cause them to be less efficient and actually diminish in capacity. Thank you.
Thank you for joining us this evening. Welcome.
Good evening, Chair, members of the committee. Chelsea Capurro, here on behalf of 2 of our clients today. First, on behalf of the Board of Oriental Medicine, we have concerns with SB 78, and we do appreciate business and industry for having conversations with us about it. Originally, we were told by business and industry that the Board of Oriental Medicine would be part of a combined board with equal board seats as with equal board seats as the other providers, and then found out through a presentation to the money committees where they shared the amendment that that was not going to be part of the case and that we would be only as an advisory committee. Acupuncture needs a strong regulatory presence as there is risk of people who practice without a license. Acupuncturists invade the body with needles, and it is possible to cause significant harm to the human body through organ puncture. They prescribe herbs that are potent and metabolically and biologically active in the body and can cause harm when not used appropriately. Acupuncturists can order blood work and imaging and operate functionally as general practitioners. We also have concerns that only having an advisory committee instead of an actual board could have repercussions as it relates to insurance coverage for patients. Acupuncturists are on the same footing in terms of being medical doctors that can make a diagnosis, prescribe a course of treatment that includes herbs, and actively intervene in how the body is functioning on both a physical and metabolic level, and would ask to be treated as such. For our second client here, on behalf of the Nevada Subcontractors Association, the Nevada Subcontractors Association also has concerns about how the Nevada State Contractors Board will be governed under business and industry. The Contractors Board is vital to our industry in protecting the public and contractors, and we will believe it'll be detrimental to our industry and diminish the value of licensed contractors. The work the board does is extensive, and their expertise is extremely important. With less governance, there will be an increased risk for consumers being taken advantage of, and we ask for the Nevada State Contractors Board to continue to operate as they currently do.
And thank you for joining us. Good evening.
Thank you. For the record, my name is Ross Kinson, K-I-N-S-O-N. I'm the president of the Northern Nevada Central Labor Council. We're representing working people across Northern Nevada, including thousands of frontline healthcare workers. We oppose Senate Bill 78 as introduced. The original bill proposed eliminating or consolidating numerous professional licensing boards in healthcare, boards that ensure safe and ethical and competent care for Nevadans. It would have placed critical decisions in the hands of a single administrator, stripping away the voices of the professionals who understand this work best. While we appreciate that some of these provisions appear to have been amended out, the intent behind the original bill was deeply troubling. Centralizing control over licensing and discipline threatens the integrity of healthcare oversight and risks patient safety. We urge you to reject any attempt to revisit these changes and protect the role of working professionals in shaping standards for their own industries. Thank you.
Thank you for joining us. Good evening.
Good evening. Can you hear me okay? Good evening to Chair and the members of the committee. My name is Agata Goronsky, and I represent the Nevada State Board of Examiners for Alcohol, Drug, and Gambling Counselors. I am here to voice our strong opposition to the Senate Bill 78. What's deeply concerning about the SB 78 is how it was developed without meaningful consultation with the boards it seeks to eliminate. Outside of a few larger group listening sessions to tell us the plan to consolidate the boards, there was no individual outreach to our board, no engagement with our over 1,400 licensees, and no attempt to understand how consolidation would impact the vulnerable populations we serve. If improving efficiency and accountability were truly the goals, why exclude the very stakeholders with the most relevant expertise? Our specialized board operates with remarkable efficiency, just one and quarter full-time staff, and a modest $200,000 annual budget that has been self-funded for decades. We've maintained stable fees for over 10 years while providing a responsible service to both licensees and the public. The proposed consolidation would dilute specialized addiction and gambling treatment expertise to just 2 representatives on a massive board. This approach directly contradicts both community good and fiscal responsibility by adding layers of bureaucracy during critical addiction treatment workforce shortage. We are absolutely committed to continuous improvement and welcome collaborative discussions to enhance our operations. However, SB 78's approach of eliminating specialized oversight without stakeholder input will harm the communities we all seek to protect. We respectfully request to be included with the 12 boards identified in recommendations number 5 that are not subject to consolidation, and we stand ready to work with all parties on more thoughtful solutions. Thank you for your consideration.
Thank you for joining us this evening. Welcome.
Hello, Chair and committee members. My name is Adrienne Renwick, for the record, ADRIENNERENWICK. I am here to speak in opposition of SB 78. I want to acknowledge the significant amendments that were proposed by Dr. Sanchez and Nikki Haig. I still have concerns. My primary concern is that this seeks to introduce, I'm speaking in a capacity as a licensed clinical professional counselor and licensed clinical alcohol and drug counselor, so 2 of the licensing boards that are proposed to be incorporated into this Nevada Wellness Board. Between all of the licenses or the boards that are proposed to be combined, there are 12 different licenses, with a 13th being proposed in SB 165. All of these licenses have different codes of ethics. They have different national examinations in order to achieve licensure. They have different academic programs that feed each of these licenses, so 6 academic programs in total. Some of the comparison states that were mentioned, so for example, the California Board of Behavioral Sciences, that has one of the longest wait times nationally for licensure. And I do fear that that could impact licensure, particularly in rural areas in our state. Finally, I want to speak to the dominance issues with the board. I think it's important to mention that these licenses that are proposed to be combined range from bachelor's level all the way up to doctoral level practitioners. And to think that there might not be an authority bias, lack of collaboration, or open communication, I think would be a misstep on our part. With the broad educational scope and varying scope of practices, I anticipate this to be a continued issue. Thank you.
And thank you for joining us. Good evening, welcome.
Good evening, Chair, members of the committee. My name is Jennifer Ross, JENNIFERROSS. I am a licensed marriage and family therapist, a licensed clinical alcohol and drug counselor, and a state-approved clinical supervisor for both boards. I'm here today as a licensee and member of the public, though as a member of one of our licensing boards, I do have some insider knowledge about the functioning of the boards. I would echo what Dr. Renwick had to say. We have over 10,000 licensees being proposed into this singular board with a range of academic requirements. We've got 4 separate sets of regulations, 6 separate codes of ethics, disparate requirements for all of the training standards among the behavioral health licenses. And so efficiency is a concern of mine as a licensee. And I just think that regulation and oversight, reduced redundancies can be done without merging these boards and watering down these professions. Thank you.
And thank you for joining us. Good evening.
Good evening, Chair Flores and members of the committee. Arelia Alarcon, spelled ARELIALARCON, on behalf of Turtle University, Nevada, the largest medical school in the state, here in opposition to SB 78. Our main concern lies with the composition of the Nevada Medical Board. We do not think that there should only be 2 doctors of osteopathic medicine on the board and think that there should instead be 4. We also think that the board should be limited to physicians. We would like to thank the Department of Business and Industry for meeting with us, and we look forward to continue working with them on this and having further conversations. Thank you.
And thank you for joining us. Good evening. Hello.
Good evening, Mr. Chair and members of the committee. I'm Sarah Adler with Silver State Government Relations, today representing the Nevada Advanced Practice Nurses Association, or NAPNA. These are Nevada's nurse practitioners referenced in statute as Advanced Practice Registered Nurses, or APRNs. First, NAPNA would like to commend Director Sanchez and his team on the depth of their analysis and the transparency of their explanation. Director Sanchez began today by stating that organization, efficiency, and accountability are Governor Lombardo's cornerstones for this work. In the experience of APRNs, the Nevada State Board of Nursing, or NSBN, hits the bullseye on all three of those metrics. NSBN was recognized as one of two boards that does not have a dominance issue. NSBN does not appear on slides 36 and 37 regarding audit findings. License applicants receive a clear and rapid licensing experience from the Nevada State Board of Nursing. They receive expert and consistent treatment across the profession as it relates to investigations, discipline, and continuing education because they have expert staff in each of those areas already serving the board. Licensees also have a voice through advisory committees. This board is clearly not broken. So it is correct that Nevada needs more nurses and more APRNs. That is why the efficiency of the current board should not be placed at risk, in NAPNA's opinion. Now, this may be only a matter of timing. NAPNA wants to, it could be that phase 5 is bringing in a large self-sufficient board in perhaps the next biennium. But the work before BNI right now suggests that the Nevada State Board of Nursing is best serving the state where it exists now. So in closing, NAPNA wants to record its serious concern about including the Nevada State Board of Nursing in this transfer to business and industry at this time, as it creates a risk to the current efficiency of board operations and impacts the board's role in investigations and discipline in order to protect the safety of Nevadans. Thank you so much for this opportunity.
And thank you for joining us this evening. I do know that we have a lengthy number of folk wishing to join us over the phone. At this point, BPS, can we go to those wishing to testify in opposition to Senate Bill 78 over the phone?
If you would like to testify in opposition of Senate Bill 78, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 185, please press star 6 to unmute yourself.
Hi, my name is Dr. Lisa Grant, L-I-S-A-G-R-A-N-T. I was the Secretary-Treasurer. I am a licensed Oriental Medicine doctor here in the state of Nevada. I was the Secretary-Treasurer on the Board of Oriental Medicine for 6 years. We have worked to meet many of Governor Lombardo's goals to improve efficiency and transparency. We worked with the Senate to revise the NRS to align licensing practice with the national standards, and we now accept the national license. We no longer require a state exam except in the area of jurisprudence because we feel that it is in the interest of public safety to make sure that our Oriental medicine doctors are actually aware of the laws governing the practice of medicine in the state of Nevada, which decreased the barriers to entry. And since we implemented these changes, we've had like double digits of Oriental medicine doctors applying and accepting to practice in the state of Nevada. We implemented an online licensure process to simplify both licensing and relicensure of our Oriental medicine doctors. We've eliminated requirements that acted as barriers that weren't in the interest of the public safety. We Oriental medicine doctors are not just woo-woo doctors, which is often the image that people have. Oriental medicine requires a master's license, and here in the state of Nevada, the educational level that is required from our doctors is just a few credits shy of what would be considered a PhD in other states. So, the board itself has worked very hard to make sure that our doctors are licensed have excellent standards of education and care. And we feel that the problem with the bill as it is currently, with SB 78 as it is currently written, is that, doctors of Oriental medicine need a strong regulatory presence because there are people who practice without a license. We are literally invading the body with needles. So we need a strong regulatory structure to prevent unlicensed practice of acupuncture. We do not feel that being part of an advisory board is in the interest of the public. We feel that we should be on the board that has an actual regulatory say. And rather than have our two seats
And
be
I
in the
apologize to
same
cut
board
you off,
as homeopaths.
but we have hit the 2-minute mark. Would you mind doing your final closing remark? And anything in addition to that, feel free to submit via email and we'll make sure it gets uploaded.
Absolutely. So we believe that since it is, we should have an actual voice on a board to express the intricacies of the medicine and make sure that in the public safety is preserved and concerned. Thank you very much.
Thank you for joining us. Next caller in opposition to Senate Bill 78.
Good evening. For the record, my name is Anna Durst, ANNA-DURST. I'm a Nevada CPA and Chief Executive Officer of the Nevada Society of CPAs. We oppose SB 78 as currently written. We provided written opposition on March 27th, but would like to make some comments today and appreciate the time of the committee. There are examples in other states where reform efforts were more harmful than helpful, especially with regards to accountancy board, on which I will focus. The regulation of the practice of public accountancy at the state level is uniquely efficient and pro-competitive. The Nevada Board of Accountancy specifically operates efficiently, is transparent, puts public protection at the forefront of their activities, and provides stellar service to their licensees. Centralizing administrative functions may work for some occupations that have similar requirements and similar public trust exposure. Professional licenses are very different. Professional licenses require internal staff who understand the profession at a deeper level, even for administrative functions. There are many moving parts to the CPA licensure, and it is important that it is managed with proper oversight and knowledge. Currently, a CPA application is processed in 1 business day, usually less. This is vital to a profession experiencing a shortage of CPAs. Licenses that are issued via the state, such as real estate, take much, much longer than that. Centralizing administrative functions is not a guarantee of cost savings. The Board of Accountancy raised renewal fees for the first time in over 40 years in 2025. They operate without general funds and maintain operations with 2 full-time employees and a handful of contracted staff while navigating inflation and the demand for new technology. This bill seeks to reduce the numbers of CPAs on the board and increase the number of public members. A board with fewer CPAs may lack the specialized insight necessary to effectively evaluate and regulate accounting practices, potentially leading to less rigorous oversight and increased risk of non-compliance within the profession.
And we have hit the
It's
2-minute
not
mark. If I
dominant.
could have you please make your closing remarks.
Okay.
The rest you can submit to the committee.
Yes, sir. Okay, it's not dominance. It's what's required to handle the highly technical issues that come before the board. In summary, we ask that you vote no on SB 78. Thank you.
Thank you. Next caller in opposition to Senate Bill 78. And callers, if somebody's already made your point, feel more than free to get your name, your title, and say you agree with the statements that were made previously. Please continue.
Hi, good evening, Chair Flores, Vice Chair Orenthal, and members of the committee. My name is Jenny Stepp, and I'm a licensed clinical professional counselor in private practice in Las Vegas. I specialize in mood and anxiety disorders, trauma, and PTSD. I serve as the Healthcare Action Team Chair for the Nevada chapter of the National Organization for Women. I'm calling today as a concerned license holder in opposition to Senate Bill 78 because of the potential for harm to the public when we consolidate and lose valuable board member voices to our profession. The field of mental health is broad and houses a number of critical licenses that overlap in some ways but function differently. in several key areas, which you've already heard. If what I'm hearing is accurate, licensed clinical professional counselors may not have adequate or fair representation in the new model. Also up for consideration in this legislative session is Assembly Bill 163, which would enter Nevada into the nationwide counseling compact. I'm excited about entering the counseling compact to provide critical mental health care to our residents, especially in rural areas, but I'm worried that the clinical professional counselors would not have appropriate representation or oversight if we go into the interstate compact. I'm confident that my own occupational board has a streamlined process for managing staff, budget, license applications and renewals, and most importantly, the disciplinary complaints and investigations. With all that's happening in the country, especially around reproductive health care and gender affirming health care, I personally want my occupational board to have the appropriate representation, oversight, and accountability to ensure public health and safety. For these reasons, I'm in opposition to Senate Bill 78. Thank you for your time and consideration.
And thank you for joining us. Next caller in opposition, Senate Bill 78.
May I go on? C-Y-R-U-S-H-O-J-J-A-T-Y. I stand in opposition. I will echo the statements made by the representatives of the American Institute of Architects. I'm an architectural drafter, urban designer, and this applies to me a lot. Other than that, thank you so much, Chair. Ditto.
Thank you for joining us. Next caller in opposition to Senate Bill 78.
Good evening, members of the board, and thank you for the opportunity to speak. My name is David James. I'm a licensed civil engineer in Nevada, and I speak today as a member of the Nevada chapter of the National Society of Professional Engineers. I oppose as currently written Section 24 of SB 78 that eliminates the 9-member Nevada State Board of Engineers and Land Surveyors. I also oppose Section 80 that constitutes a new multidisciplinary board of professional design and environmental specialists with 4 engineers and 1 land surveyor member. I oppose these bill sections because Nevada needs to preserve the current qualified 6-engineer, 2 land surveyor, and 1 public board member board with a clear focus to review licensure and implement discipline of 28,000 active engineering and 600 active land surveying licenses in Nevada. The current board meets regularly and transparently to review the continuing large licensing workload and manage disciplinary cases. Reducing representation to 4 engineers and 1 land surveyor on the new multidisciplinary board will increase workload on fewer qualified board members, and as a result could put public health and safety at risk if reviews were to become less thorough due to member time limitations. Speaking personally, I have received fair and prompt service from the current State Board of Engineers and Land Surveyors for 27 years. I support the current board's organization, meeting schedule, and operations. Therefore, I request that the State Board of Engineers and Land Surveyors be removed from SB 78 by being placed on the exempt list, and that it be allowed to continue to operate as currently organized, staffed, and funded. Thank you. I appreciate your time today.
And thank you for joining us. Next caller in opposition to Senate Bill 78, please.
Thank you, Chair and members of the committee. Elliot Mallon for the record on behalf of the Nevada Osteopathic Medical Association. First, I want to thank the Department of Business and Industry for meeting with us and talking with us. We raised 2 major concerns. One, we were originally told there would be parity between the allopaths and osteopaths on the new medical board. That is no longer the case, and it has been lowered to 2 osteopaths and 4 allopaths. Number 2, we are concerned that the new medical board would actually include chiropractors. Currently in Nevada, there are 2 medical boards, the allopathic medical board and the osteopathic medical board, only licensing doctors of osteopathy and allopathy. Including the chiropractors would expand the scope, and that's something that we just are not in favor of at this point in time. Thank you very much, and thank you, everybody.
Thank you for joining us. Next caller in opposition, please.
Good evening, Chairman, ranking members, of honorable members of the Senate Committee Government Affairs. My name is Dr. Henry Locke, LOK. I'm American Osteopathic Board Certified Family Medicine and Pain Medicine Physicians, licensed in the state of Nevada, and the current president of the Nevada Osteopathic Medical Association. I represent osteopathic physicians in Nevada dedicated to delivering high-quality healthcare and advancing public incentives, and I stand before you in opposition of Senate Bill 78, which proposed the merger of the Nevada State Board of Osteopathic Medicine with other regulatory bodies. While the intent to streamline the government operation is commendable by Governor Lombardo, this proposal risks undermining distinct values of osteopathic medicine and welfare of Nevada patients. First, the Osteopathic Board serves as a specialized role overseeing physician training as a whole person approach and emphasize preventative care body's interconnected system. Merging it with other boards will dilute the unique perspective of osteopathic physicians or DOs, bringing critical diversity in Nevada's healthcare system. And the regulatory oversight must reflect their specific training and philosophy. A consolidated board may prioritize standardization over specialization, eroding identity and autonomy of the osteopathic practice. Second, the merger threatens the patient care, and the osteopathic board ensures DO meet rigorous standards tailored to their practice. Combining boards lead to oversight gaps. An unfilled entity may lack expertise to address nuances of osteopathic medicine. Patients who rely on DOs, many in underserved areas, deserve regulators who understand samplers, who understand their needs, that not one size fit all approach. Third, efficiency does not guarantee effectiveness. The fiscal savings promised by this merger are speculative. While the cost, confusion, reduced accountability, and the potential delays in licensing could burden both physicians and the public. The Nevada healthcare system thrives on choice and clarity, not conciliation for its own sake. Fourth, no financial incentives for the state. The DO boards run on its own revenue. Merging doesn't save the state money. The DO board is healthy. It has reserve and all the public information. Fifth, disruption without benefit. A self-funded DO board is already efficient and independent, tailored to osteopathic needs. Merging with this system risks upsetting this balance and adding complexity of oversight issues without offsetting state costs. Six, potential hidden costs. Even the DO boards of sustaining integrating might require state resources and could ironically create expenses where none existed, negating this streamlining argument. And seven, undermining a working model. A self-funded DO board proves.
And thank you for joining us. We have hit the 2-minute mark. If I could have you do your last closing remark, please.
Yes. I urge you to preserve the osteopathic board independence, ensuring that it continues to serve as a dedicated advocate of osteopathic physicians and their patients. Reject Senate Bill 78 and let us prioritize quality over expediency. Thank you.
And thank you for joining us. Feel free to send your entire remarks via email. We'll make sure they get uploaded. Next caller in opposition to Senate Bill 78, please.
Caller with the last three digits of 779. We can see you're unmuted. Please continue. Is it possible that you are muted on your end?
How about now?
There you go. Please continue.
Okay. I'm sorry. My name is Jordan Crane-Buell. I'm the Executive Director of the Plumbing, Heating, Cooling Contractors of Nevada, speaking in opposition of SB 78 in regards to the State Contractors Board. We believe that the State Contractors Board is very unique. One size does not fit all. They do a great job. Our concerns include the makeup of the board members. Decreasing the contractor members on the board is a mistake. We're worried about the increase in licensing fees, staffing issues, including investigators. They have a hard time keeping up as it is, and life safety issues in regards to increased level of bureaucracy that increases response times and investigation time. Thank you very much for your time.
And thank you for joining us. Next caller in opposition to Senate Bill 78, please.
Hi, my name is Sharon Roth. I'm a doctor of Oriental Medicine here in Nevada and have been for the past 24 years, actually. I wanted to speak in opposition to the Senate bill because while I too appreciate efforts to modernize and towards efficiency, my personal experience has been that the Board of Oriental Medicine has been very efficient. And as my colleague Dr. Grant said earlier, they have taken lots of steps to come into line with the goals that the governor has stated for these boards. And furthermore, doctors of Oriental Medicine are physicians in this state and have powers as primary care physicians, as a matter of fact. So just being on an advisory board where there's no voting rights really doesn't seem appropriate to what our profession really needs to oversee physicians in the state. And I just want to thank you for your time, but I would like to voice my opposition. I think that the board is running just great the way it is. And if it was going to be grouped with with a larger set of other professionals, we should definitely have voting rights, not just be in an advisory capacity. Thank you.
And thank you for joining us. Next caller in opposition.
Good evening. My name is Tom Durante, and I am a licensed clinical social worker and private practitioner. I'm here to testify in opposition to SB 78. The merging of various behavioral health boards will lead to less focused approach to regulation and oversight. The social work profession is a diverse and unique profession with various levels of licensure. SB 78 will dilute the expertise of the board at these various levels and in unique social work duties. I do not believe that consolidation of behavioral health boards serves the community. Right now, I can call my board with a question or concern and receive immediate response. And I am concerned that this resource will be lost for myself and for all in our community. Thank you.
Thank you for joining us. Next caller in opposition.
Caller with the last three digits of 649, please press *6 to unmute yourself. Please continue.
Thank you, Chair Flores and committee members. For the record, I am Robert Carrington, Carrington. I'm here representing the Nevada Association of Land Surveyors, and with respect, we are opposed to the portion of SB 78, which proposes merging the Nevada Board of Professional Engineers and Land Surveyors with the Board of Environmental Health Specialists. While I understand the intent is to improve efficiency, this consolidation will be detrimental to the licensing process and, most importantly, public protection. The Nevada State Board of Professional Engineers and Land Surveyors operate entirely on licensing fees, making itself a self-sustaining entity that does not burden the licensees or taxpayers. There is no financial justification for merging this board, and it's already financially functioning efficiently and effectively without requiring public funds. The board is highly efficient in processing both in-state and reciprocity licenses, ensuring that qualified engineers and land surveyors can enter the workforce quickly. Merging with the board of environmental health specialists will have a vastly different regulatory process and would likely create bottlenecks, delays, and inefficiencies, hindering Nevada's ability to put people to work in a timely manner. The environmental board does not align with the Nevada State Board of Engineers and Land Surveyors, and that is being proposed for merger, while engineers and land surveyors fall under the umbrella of design professionals. Environmental health regulations are fundamentally different, dealing with public health, sanitation, and environmental safety. The proposed merger assumes consolidation will improve efficiency, but in reality, it could introduce greater administrative complexity, slower decision-making, and reduce responsiveness to industry-specific concerns. Rather than improving operations, SB 78 could delay licensing, reduce enforcement, effectiveness, and ultimately harm both professionals and the public. I sent this letter with other recommendations to the board this morning. For all members, thank you for hearing me today.
Hi, and thank you for joining us. Next caller in opposition, please.
Hello, my name is Robert Piccini, P-I-C-C-I-N-I-N-I. I am an osteopathic physician who practices psychiatry and currently serves as the president of the American Osteopathic Association. Thank you for this opportunity to share testimony in strong opposition to Senate Bill 78. DOs and MDs alike complete 4 years of medical school, 12,000 to 16,000 hours of postgraduate medical education, and a 3-part licensing exam, contrary to non-physician chiropractors. On top of this, osteopathic physicians complete additional training in osteopathic principles and practices, which allow DOs to treat patients via a comprehensive whole person approach to medical care that encompasses body, mind, and spirit. DO licensing exam series, the comprehensive osteopathic medical licensing exam of the United States, specifically tests osteopathic physicians' competencies and similarities. Osteopathic medical boards serve the important purpose of evaluating the fitness of individuals, specifically for osteopathic medical practices in the state. The Nevada State Board of Osteopathic Medicine, or SBOM, has been regulating those in the state for 50 years and is financially self-sustaining. For this reason, the AOA and our osteopathic partner organizations stand together in strong opposition to Senate Bill 8. We urge you to reject this unnecessary and counterproductive incursion on professional self-regulation. Thank you for your time.
And sir, before you get off, I would highly recommend that you submit your testimony via email to our committee, as unfortunately the signal was poor and you were cutting off and we couldn't get the full breadth of it. Please do submit it in writing. Thank you. Next caller in opposition, please.
Hi there, my name is Jamie Vaughn, and I am a board member on the Board of Examiners for Social Workers. Good evening, Chair and members of the committee. I am here today to express my strong opposition to Senate Bill 78. While I recognize the bill is intended to improve accountability, I firmly believe that it poses significant risk to the integrity and effectiveness of the board's decision-making process, and could lead to unwarranted dismissal of its leadership. The underlying premise of SB 78 is that it will increase accountability. However, in practice, the bill undermines the independence that is crucial for our board to operate effectively and serve the public without undue political interference. A board that is free from external pressures is essential to ensuring that decisions are made with the best interests of the community in mind, rather than for political gain. What is perhaps most troubling about this bill is the way it has been introduced, without adequate transparency or engagement with those it will affect. There has been no consultation with the board, no formal inquiry into how we operate or how our decisions are made, and no outreach to stakeholders or the broader community to discuss the potential consequences of this legislation. This lack of dialogue is deeply concerning, particularly when the stakes are so high for people we serve. As a board member, I can assure you that we are fully open to working together to enhance communication and transparency in ways that preserve the integrity and independence of our operation. We are committed to engaging in meaningful discussions to address any concerns and to find constructive solutions that serve the public's best interests. However, SB 78, as currently drafted, threatens to destabilize the governance structure that allows our board to operate in the best interests of the public. It risks politicizing the decision-making process and could create an environment in which the board is less able to fulfill its critical responsibilities effectively. For these reasons, I respectfully urge this committee to reconsider the implications of SB 78 and oppose its passage. Thank you for your time and attention and the opportunity to share my perspective.
Thank you very much. And I would like to remind those wishing to testify in opposition, if somebody's already made your point, feel free to ditto the comments before, get your name on the record and the board that you are a part of. Anyone else in opposition, please?
Caller with the last digits of 869. Oh, please continue. Thank you.
My name is Amanda Simons, S-I-M-O-N-S. I'm a licensed clinical social worker here in Las Vegas, Nevada. And I am a former member of the Nevada NASW Board of Directors, and I am in opposition of Senate Bill 78 to put all of the behavioral health boards under one jurisdiction, just
does our community and our state a huge disservice, as we all have several different codes of ethics. We have several different levels of certifications. We concentrate in many different areas. And as social workers, we serve in a variety of different organizations in a variety of different areas of services from birth to death. We serve in different agencies, and to be able to call one board and have a group of individuals who understand their code of ethics, who understand our training, who understand our different environments that we all work in, and be able to get a understanding and get a true answer is very helpful to us. And to be able to have a national organization that we can call as well and consult with, and is very beneficial to our entire state. We're creating a pipeline. We are the largest mental health providers in the country, and to put us under one umbrella with everybody else and to lump us is just detrimental and sets us back in the state. Thank you.
Thank you for joining us. Next caller in opposition, please.
Caller with the last three digits of 600, please press *6 to unmute yourself. Please continue.
Thank you. Good evening, Chairman Flores and distinguished members of the committee. This is James Morris, and I am the former executive director of the United Opticians Association. I'm here in opposition to the bill as presented on behalf of opticians and optometrists. I did submit a letter in opposition. I won't reiterate what's in that letter. There's some very personal with regard to why this is critical to patients throughout your state. But I do want to identify on behalf of Senator Daley with regard to the questions regarding the dominance and competency. Very concerned with regard to the issue of dominance, because I believe it's being misrepresented by the party trying to present this to you. With regard to the North Carolina case, it's not about dominance with regard to the manner in which it's set forth in Nevada. It was how it was being done in North Carolina specifically by the dental board. That's not what's being done here. The other issue is opticians are entirely different from optometrists. So the way it's now been presented for the first time this evening is a dual board with those two professions. Optometrists are like the physicians. They prescribe, they write out a prescription on behalf of the patient. They hand it to the patient, and the patient goes to the optician, who's like the pharmacist. And in that context, if you combine these boards, you now have pharmacists and physicians monitoring each other. And that's not wise, and it's not beneficial to the health, safety, and welfare. The other issue that Senator Flores, Chairman Flores, raised that is important as well are all of the contract implications and all of the issues with regard to the various contracts, including between optometry and opticianry. This situation, although well-intentioned by Dr. Sanchez, is a good example of good intentions make bad law. There's too much being included, too many things being combined.
And we have hit the 2-minute mark. If I could have you do your closing remark, please, and please submit the rest to the committee.
Yes. Yes, Chairman Flores. This bill as presented does not save money. It does not protect the health, safety, and welfare. It does not provide any clarity and it is not appropriate as presented. It does not streamline your laws.
And thank you very
We
much for joining
respectfully
us this
request
evening.
that you
Thank you.
deny. Thank you.
Thank you, sir. And we'll go to the next caller in opposition, please.
Hi, my name is Rachel Cole. I'm the owner and director of Integrative Acupuncture in Las Vegas and a proud fourth-generation native Nevadan. I strongly oppose this bill, SB 78, in its current language, which excludes Oriental medicine doctors like myself, and puts us into this advisory committee with homeopathic medicine, which I don't feel is appropriate. It's very concerning. There's not a fair comparison between our two boards. As they stated in the presentation, homeopathics is only licensed in one state, which is Nevada. Acupuncture and Oriental medicine is quite different. We're licensed in 48 states, and we're not a fringe or alternative medicine at this point in time. We're a newer field in medicine in the West, but over these many years, we are integrated into national public and private hospital systems, the Veterans Administration, covered by private insurance, covered by Medicare. So it's very important for us to be, if this restructuring is going to happen, that we're on par with other similar medical professionals and not sort of relegated into this advisory committee, which sets a precedent, in my opinion, respectfully, for marginalization and regulatory bias to exclude us as a legitimate healthcare and provider type, which could down the road limit patients' access to care, which we all know is already a huge issue in the state of Nevada. Thank you very much for the time.
Thank you for joining us. Next caller in opposition, please.
Caller with the last three digits of 388, please press *6 to unmute yourself. Chair, it looks like this caller is having difficulty. I'll put through the next caller.
Please do. Thank you.
Caller with the last three digits of 255, you are unmuted. Please continue.
Good evening, and thank you for this opportunity to share testimony in opposition to Senate Bill 78. My name is Michael Kolinsky, D.O., Kolinski. I'm a practicing osteopathic physician, specialize in neuromusculoskeletal medicine and pain management with offices in Carson City, Reno, and Sparks. I speak on my own behalf in opposition to this bill, both as introduced and amended on March 13th. While I stand and echo and stand behind many of the points that my osteopathic colleagues have already mentioned in opposition, I'd like to mention a few points. Nevada DOs have effectively and efficiently been self-regulated by a jury of their peers for over 50 years. Additionally, the State Board of Osteopathic Medicine is financially self-sustaining. SB 78 disregards these facts with no clear benefits to patients or taxpayers. The DOs in the United States complete the same basic medical education and training as MDs, but they also complete additional training in osteopathic principles and practices, which MDs and chiropractors do not complete. Bottom line, DOs have unique training. The current state Board of Osteopathic Medicine regulates and adjudicates complaints regarding the very unique practice of osteopathic medicine by osteopathic physicians, not chiropractors or MDs. Furthermore, I believe there are some terminology issues with the bill. The bill uses the term doctor to refer to MDs and DOs, while the term physician is exclusively used to refer to chiropractors. While all three do hold doctorate level degrees, they are not all physicians. Chiropractors do not complete the same level of comprehensive medical education, training, and testing that DO and MD physicians, in quote, complete to obtain physician licensure and independently provide medical care to patients. Additionally, the bill only establishes a 4-person MD majority
among the practitioner board members, with DOs receiving the same number of seats as chiropractors at 2. While Director Sanchez states that these numbers are in line with the population numbers of those in those occupations and the complaints, I do believe that DOs deserve a fair jury by their peers.
And we have hit the
For
2
these
minute mark if
reasons,
you want
I
to do your
stand in
closing remark,
opposition
please.
to Senate Bill 78.
Thank you. Next
I
caller in
do
opposition,
stand
please.
in opposition to 7.
Caller, please continue.
Yes. My name is Dr. Victor Clausen. I'm an osteopathic physician in the state of Nevada. I've practiced occupational medicine for 25 years. And I'm actually unique because I can hear all the arguments. I've served on the Nevada Board of Oriental Medicine in 2005. I've been the president of the Nevada Osteopathic Medical Association 2010 and 2021, still a continued board member in the Nevada Board of Osteopathic Medicine. And I'm just going to say some very clear points because you've heard a lot of things and I don't want to reiterate everything else. I just want to make it very clear to the lawmakers of the state of Nevada, ladies and gentlemen that represent our state, that osteopathic medicine is a very unique field. Out of the osteopathic doctors that graduate, and here our second medical school in the state was Truro University, 50% of the doctors become primary care physicians and care for all the people that you represent at every level. And we've managed to sustain ourselves for 50 years with a financially and fiscally responsible board that has actually led the way and been leaders in medicine in the state. And it seems to me that this bill, SB 78, just gives us a slap in the face. If we're not represented equally with our allopathic brothers, it doesn't seem fair. We've done our due diligence in the state and we deserve representation on this board. If it goes through, I just plead with the lawmakers of the state of Nevada to give us equal representation as we deserve. Absolutely. Thank you.
And thank you for joining us. Next caller in support, please. The opposition. Next caller in opposition, please.
Hi, my name is Andrew Rivas, R-I-V-A-S. I am a Nevada resident of Senate District 13, and I just wanted to express strong opposition that's already been raised by all of the surveyors, engineers, contractors, nurses, doctors, social workers, educators, and others on this call. I would also just like to express my frustration that while this bill deals with making the state more transparent, the transparency to the public has been very little. This morning when I punched in for work, this bill didn't have a hearing that I could find. Before I punched out today to come home, this bill was already being heard. I urge the committee to stand with Nevada's licensed professionals to make sure that we actually have representation, because at the end of the day, it's going to affect people like me and my ability to access all of the services that all of these licensed professionals are providing to all of us here in the state. Thank you.
And thank you for joining us. Next caller in opposition, please.
Hello, my name is Sang-hyun Lee. I'm the president of the Wongu University of Oriental Medicine and also representing the Nevada Oriental Medicine Board. I would like to oppose the SB 78. The first reason, the OMD, the training requires the 3,500 hours of the Western Oriental Acupuncture Herbal Medicine training. And number two, the Nevada OM board is self-sustaining. So hope we can reconsider this becoming the advisory board. Thank you.
Thank you for joining us. Next caller in opposition.
Caller with the last three digits of 450, you are unmuted. Please continue.
Thank you, Chair and Committee. For the record, my name is Beth Scott. I come to you as a licensed clinical social worker in firm solidarity with every professional who spoke in opposition to Senate Bill 78. I too oppose this bill, parroting similar concerns, primarily related to differences in scope of practice, differences in education, lack of understanding for other professionals. This bill seems irresponsible physically and professionally, and potentially dangerous to those, not only ourselves, but also to those whom we profess to protect. It is very clear from the amount of opposition that those who are part of these boards do not want this. I beg you, please oppose this bill. Thank you.
And thank you for joining us. Next caller in opposition, please.
Good evening, Chair and members of the committee. My name is Wendy Noor. I'm the Executive Director of the Nevada Board of Applied Behavior Analysis, and I'm here representing them in opposition of SB 78. The concept of this bill began with SB 431 and its passage in the last session, June of 2023. In similar fashion, that bill had little review, discussion, or collaboration before it was hastily approved late one evening on one of the last possible days of the session. After reviewing notes and comments from the governor's representatives at that time, SB 78 does not even come close to what was presented nor approved in concept at that time. Almost 2 years later, here we find ourselves now just 58 days away from the end of a session without even a final bill to review. There's been no real public discussion or an opportunity for collaboration to ensure these efforts are in the best interest of the public the licensing boards are commissioned to protect. This is the first hearing made available for any comment, and it was added to the agenda at 9:30 this morning. What a disservice to the professionals of the state who will be directly impacted by this proposed bill, and most importantly, the public we all serve. There's also been no mention of SB 425, a competing bill of a similar consolidation effort through DHHS for 5 of the boards, including ours. Are you really going to rush through this session with a bill of this complexity and wide-reaching implications without allowing for full disclosure, full participation, and true discussion and refinement? A great deal of misinformation has been presented, painting a picture of gross inefficiencies, poor management, fiscal improprieties, and ineffectiveness of all the boards, without an opportunity to really explore the misinformation and address any of these concerns. Underlying concerns of antitrust issues and board composition can be addressed through revisions and regulations of those identified boards. As mentioned, it's taken 100 years of legislation to bring us to where we are today. I think we're all deserving of more than 58 days. Let's make real, thoughtful improvements. SB 78 doesn't do that, and I urge this committee to oppose SB 78. Thank you.
And thank you for joining us. Next caller in opposition.
Hello, my name is Emily Oberlies, O-B as in boy, E-R-L-I-E-S for the record. Speaking in opposition of the bill, I'm a fourth-year osteopathic medical student at Touro, Nevada, on the cusp of graduation and entering into a family medicine residency program. Osteopathic manipulative treatment is central to our training as DOs with our focus on whole body medicine, and I chose DO to specifically learn osteopathic training. And with this proposed merger of boards, it leaves me uneasy as we have an imbalance of DO and MDs and other professions on the board. And I've seen, firsthand during my residency interviews and rotations that there is still some bias for one towards the other. I'm worried that this merger could cause delays in licensing and boarding with potential bias. Furthermore, all of us have different certifications and licensing requirements that we need to maintain our CME credits, and having one entity juggle all of these different needs could cause some unnecessary delays in our state and confusion. I'm currently applying for my resident training license, and it has been sufficiently belabored process dealing with a board that is specifically dedicated to my profession, who knows exactly what paperwork is needed for the specific license that I'm applying for. And I cannot imagine the nightmare of trying to repeat this process in a merged board and receiving potentially wrong information. A super board may aim for uniformity and efficiency, but it sacrifices the uniqueness, representation, and identity that defines each of our specialties. And for this reason, I am opposed to SB 78. Thank you.
Thank you for joining us. Next caller in opposition to Senate Bill 78, please.
Caller with the last three digits of 065, you are unmuted. Please continue.
Hello, can you hear me?
Yes, we can.
Oh, thank you so much. So I'm excited to be here. Been looking forward to speaking to the chair and the committee members. So my name is Dr. Teresa Hupka. I am the president of the American Osteopathic Association, and I am an osteopathic physician who practices obstetrics and gynecology. The AOA represents more than 197,000 DOs and osteopathic medical students nationwide, including nearly 3,000 in Nevada. And we join the Nevada Osteopathic Medical Association, the Truro Nevada College of Osteopathic Medicine, and the National Board of Osteopathic Medicine Medical Examiners today in opposition to this bill, in particular, Section 86. So we are opposed because this bill, as it is introduced and amended on March 13th, does not serve the public well. As you know, Senate Bill 78 eliminates the state's existing DO and MD boards and creates a new combined board of medical examiners, which regulates both DOs, MDs, and other non-physician individuals. So physicians, osteopathic physicians and allopathic physicians are the only fully licensed and trained physicians. As far as the other individuals, we went from a board of 7 osteopathic physicians down to 2, and it puts us on par with the chiropractic doctors. So allopathic or MD physicians and osteopathic DO physicians are both fully trained, distinctly different in the practice of medicine. We are 4 years of medical school and 12,000 to 16,000 hours of postgraduate medical education, and a numerous licensing, 3-part licensing board series. We are, again, on top of this, the DOs complete additional training in osteopathic principles and practice, which allows DOs to treat patients in a comprehensive, whole person care with the body, mind, and spirit approach.
And
So
thank you. We are at the 2-minute
sure
mark.
that our
If I could have you
DOs
do your closing remarks, please.
Thank you so much. Yeah, so we will submit, and I will say this, we do oppose this bill 78. So appreciate your time. Thank you.
Thank you for joining us. Next caller in opposition, please.
Thank you, Chair, and other members of the committee for allowing me time. My name is Marcus Tesseder, spelled Teissede for the record, and I'm a practicing licensed clinical social worker located in Reno. I share my fellow colleagues' concerns and points about the current language of SB 78. I'd like to add that the way the information was presented tonight feels they are copy and pasting from other states to address the concerns of efficiency, accountability, and modernization. The concern is that there are so many factors that go into why this methodology may work for other states, likely influenced by culture, funds, and geography, and this isn't guaranteed it would work for Nevada. I wish the team proposing SB 78 would have offered possible solutions to the hypotheticals presented by the committee to show that there had been research on how this is going to apply to Nevada's unique professional culture. Currently, the information presented tonight feels as if the plan is to take control and figure it out later, but the team will take this into consideration for future revisions. Thank you.
And thank you for joining us. Next caller in opposition, please.
Chair, you have no more callers in opposition at this time.
Thank you. At this time, we'll move to those wishing to testify in the neutral position. We'll start with those here in Carson City or Las Vegas. Good evening. Welcome. You are in the after hours of government affairs. Whoever wishes to go first.
Thank you, Chair and members of the committee. My name is Caleb Cage, spelled C-A-G-E, on behalf of the Children's Advocacy Alliance. I'm here to testify in neutral for Senate Bill 78. We must take every opportunity at the Children's Advocacy Alliance to emphasize the necessity to maintain a focus on children's issues where relevant. This can be achieved by appointing members to these various boards with expertise in child development, education, and mental health explicitly, ensuring that children's voices and needs are adequately represented in decision-making, discipline, and all aspects of the board. It's vital to prioritize children's well-being across all relevant boards and commissions. Thank you very much.
And thank you for joining us. Hello.
Good evening. My name is Monica Harrison. I'm the Executive Director for the Nevada State Board of Architecture. Harrison, I'm sorry, H-A-R-R-I-S-O-N, it's too late. On behalf of my board, I'm testifying neutral on SB 78. Although the Nevada State Board of Architecture is in favor of oversight, we firmly believe that centralizing the board's administrative staff is unnecessary and risks disrupting the efficiency and effectiveness already achieved. The Nevada State Board of Architecture operates transparently, enhances efficiency, minimizes the cost to licensees, delivers exceptional service, and supports the Nevada's economy. The board's track record demonstrates that its current structure is both effective and essential for fulfilling its legislative mandate. Thank you so much for allowing me to testify today.
And thank you for joining us. Good evening, sir.
Good evening, Chairman Flores and members of the committee. Greg Ernie, last name E-R-N-Y. I'm also a member of the Nevada State Board of Architecture, Interior Design, and Residential Design. Our board supports Governor Lombardo's desire to improve government. We also stand totally behind the goals that are expressed in SB 78. We stand behind it so much that we feel going forward with the SB 78, the way it is written, takes the State Board of Architecture, Interior Design, and Residential Design backwards. We have gotten gold stars in terms of all our peer reviews, all of our audits from both the legislative and executive branches of the government here in the state of Nevada. We've implemented all the regulations. We turn people around in 3 days who come to Nevada to become licensed. We are ready to implement any constructive improvements, but we're not sure that this bill is the one that actually takes it there, or at least we want to express our concerns. We have additional information that we will provide to Dr. Sanchez and to this committee in terms of outlining why and how we accomplish those goals already. I would like to point out that I'm a past president of the National Council of Architectural Registration Boards, the body that governs licensing or implements licensing for architects across the nation. One of the outcomes of the things that happened with the North Carolina board and all of a sudden moving professionals from boards is another layer of regulatory oversight gets introduced, because when you remove the professionals from the boards because there's a concern of dominance, you have to put in another layer of professional expertise in the form of an advisory committee to those boards. And that's just something I observed in my leadership position across the state. So with that, I thank you for your indulgence. And for those of you who don't know, Florida won the national champion.
And although it was neutral, I would suspect that sounded a little bit more like opposition, but I understand the desire to be respectful.
Just the facts.
But we 100% can go ahead and label that opposition, no issue with that. We will go to the phones. Anybody wishing to testify in the neutral position to Senate Bill 78, please.
If you would like to testify neutral on Senate Bill 78, please press *9 now or raise hand in your Zoom window. Caller with the last three digits of 124, please press *6 to unmute yourself.
Hi, this is Corinne Sedrin. I am calling on behalf of the Board of Dispensing Opticians. I'm the executive director, and I don't know if I'll be allowed to speak. I did wait on the phone for nearly an hour to speak in opposition, and my hand was raised and I wasn't called on. Am I still allowed to give my comments?
We will open it up for opposition for this call. Please continue in opposition.
All right. Thank you so much. I'll try to keep it quick. The sponsors of SB 78 have indicated that this bill will not remove or amend any of the current authority of the boards or the requirements related to licensure. However, this is unlikely to be the case, as the proposed bill would require a complete overhaul or repeal of our board's current statute in order to combine our board with the Board of Optometry. Furthermore, rulemaking is the preeminent authority of the boards under their current statutes, and this authority would be completely superseded by the authority of BNI under this bill. Also, the report presented by BNI includes plenty of studies and data pertaining to the supposed issues with regulatory boards. However, much of the data the Nevada boards have supplied to BNI are misrepresented in the report in various ways, specifically with respect to our financial situations and number of consumer complaints received. Director Sanchez with BNI indicated Nevada would be only the second state to enact total reform following the model of Iowa. However, Iowa only completed the restructure recently, and there's no data from that state at this time from the perspective of licensees or the public on the effectiveness of the new model. Iowa is also dealing with an entirely different regulatory model to begin with. I'm concerned that during his testimony, Director Sanchez referred to attorneys as subject matter experts for purposes of adjudicating complaints. Attorneys are not professionals in the field. They provide a supporting function and provide legal expertise, but they are not subject matter experts. They rely on the expertise of the board members, which is why those board member positions exist. The boards or the bill sponsors have indicated the transition to the new board structure will take place over 2 years. It's unrealistic to assume the current board members and staff will be either willing or able to remain in place and assist with the transition phase once their individual boards have been eliminated. This could prove to be a major impediment to the implementation of the proposed legislation and has not been addressed by the bill sponsors. That's it for me, but thank you. For these reasons, I urge the members of the committee to vote no on SB 78.
And thank you for joining us. For any remaining caller, please note that we are on neutral. You may have recently logged in. We urge you, if you are in support or opposition, that you please submit your comments in writing so that they can be uploaded to the record. But please note, we are in neutral. Next caller in support of, in neutral of Senate Bill 78.
Eric Wilcox, W-I-L-C-O-X. Chair Flores and members of the committee, thank you for the opportunity. I'm the parent of a deaf child, and I'm chair of the Nevada Commission for Persons who are Deaf and Hard of Hearing. Speaking tonight on behalf of the commission. We came tonight in opposition to this bill, as the language currently posted called for the elimination of our commission. If I'm understanding the amendment correctly, that is no longer the case. Since the establishment of our commission was a hard-fought win for the deaf community in Nevada, we are grateful to hear about the proposed amendment, and we are now neutral on the bill as amended. Thank you.
Thank you for joining us. Next caller in the neutral position.
Good evening, Mr. Chair, members of the committee. Stephen Cohen for the record, liaison for the Nevada Governor's Council on Developmental Disabilities. Come before you, number one, to ditto Mr. Wilcox, who you just heard from. In addition, we want to highlight the important work additional disability boards, commissions, and councils do, which we feel would either be eliminated, silenced, or altered through either a change in membership and or merger with others. Those are the Commission on Autism Spectrum Disorders, the Commission on Services for People with Disabilities, the Commission on Behavioral Health. This one's going to be a 2-minute exercise by itself. The Advisory Committee on Language Development for Children who are deaf, hard of hearing, or visually impaired. And as was heard earlier, the Board of Applied Behavioral Analysis. Thanks for your time.
And thank you for joining us. Next caller in the neutral position for Senate Bill 78.
If you are using your computer, please press your mic audio button in the lower left-hand corner to speak. Chair, it seems this computer user is having a hard time unmuting. That is the last caller you have this time.
Thank you. With that, if you are on the computer, feel free to either send us an email and/or contact our office, and we can help get your testimony uploaded. Is there anybody else in the neutral position, either in Carson City or Las Vegas? Seeing none, I will call our Director Sanchez back for closing remarks. Before we get to his closing remarks, I do want to address the callers who were attacking the process for clear, just for clarity. Senate Bill 78 has been out for months. People knew that this conversation was happening. In fact, a lot of the folk that brought up opposition said that they had the opportunity to meet with Director Sanchez and specifically indicated that they just were not in support of what he had brought up. He had been meeting with folk in the interim. He has been meeting with folk throughout the past several months. Everybody was free to send me emails. Folk have been meeting with me, have been sending me emails, have been sending me letters. They've been doing the same thing with the members. At no point was anybody ever limited from meeting with us or talking to us or explaining that they had any concern. Today at 7:07 p.m., opposition started. They went on for about an hour and a half. And had more individuals called in, we would have allowed them to continue in opposition. So the process has been pretty fair. Everybody has known about this bill. Director Sanchez has met with folk. I understand individuals may not agree with him, but the process has been pretty clear of what the intent was. The governor has talked about this. There are no secrets as to what the intent of Senate Bill 78 is. And if anything, Director Sanchez has limited what the original intent was to make it a little bit more palatable and easier for us to engage in this dialogue. So while we may disagree with the director or anybody else, there's been nothing but transparency in this process, and I do applaud and appreciate the director for the work he's been doing in tackling such a difficult task alongside of your staff. But please do continue with your closing remarks.
Thank you, Chair. I appreciate Chris Sanchez for the record. I appreciate those remarks that you just made greatly. I also appreciate everybody hanging in there in both opposition and in favor of the bill. It was good to hear from you. I just want to reiterate a couple of points. On the Department of Business and Industry website, under the Boards and Commissions tab, we have posted everything that you heard tonight. We have been doing so as we have generated it for the last several months. This has been a process that's been going on for, I think we're in our 10th month now. And I understand that there are folks that feel like they didn't have a voice. We have tried to get in front of as many people as would meet with us, and we tried to be as transparent as possible. And we will continue to do that. So I encourage you to reach out to us directly. Just a couple of points of clarification. One of the references was about the transparency of the B&I budget as it pertains to what we're proposing. That is all on the record now. We had our budget hearing 2 weeks ago. There's a lot of detail there. There is additional follow-up that we've done with LCB, and that information, I believe, is posted, and if not, it will be soon. And that goes to great detail, as we're required to do, around how we will approach the budget as it pertains to the fiscal side. The other thing is that the numbers that are presented with respect to our PowerPoints are derived from two sources and two sources only. The LCB audits, which can be found through the legislative websites, as well as the surveys that we conducted about 7 months ago from our boards. So the data that we have with respect to their fiscal status was provided by each individual boards. Now, I wish I could say to everybody that's listening that all the boards sent every bit of information we requested and that it was accurate. Unfortunately, that is not the case. So we will continue to take in the information that is given to us. If the boards would like that data to be accurate, they need to ensure that what we get is accurate so that we can accurately represent it. Unfortunately, we have not been able to get accurate data from every single board. And I look forward to reviewing what was submitted today as a part of our P&L requirement. The other thing I wanted to mention real quick is that the SB 431 transferred the occupational licensing boards to business and industry. There was a lot of comments about that kind of alluded to the fact that folks desired that to not be the case, but that has already happened. That was what came out of SB 431 in the last session. So the boards are at business and industry. Now the responsibility falls on me to implement 431 and to get to a system that is better structured so that we can accurately do our job. I'll leave it at that. I know there was a lot of points that were raised. Again, I do appreciate everybody's feedback, regardless of where you sit on this issue. I think there are areas where we'll agree to disagree, but in order for the policy process to work, we have to continue to communicate and talk, and I welcome anybody to reach out and talk to us directly. Our door will and has been open. Thank you, and thank you, Chair, and thank you to the committee.
And thank you for the extra after hours of government affairs. We do appreciate you being with us today, Director, and to your great staff. Before we get to public comment, I do want to just very quickly thank our amazing staff here in Government Affairs for helping us coordinate with the food, long hearing. Some of them have to drive far after this hearing, and so I'm just very appreciative of having such amazing folks. We would not be able to do this without them. With that, we'll go to the very last item on the agenda, which is public comment. I want to invite those of you wishing to join us for public comment and remind you that we are not going to relitigate Senate Bill 78. We have now closed that hearing. Anything that falls within the general purviews of our committee, and we will limit testimony to 2 minutes. Anybody in Carson City or Las Vegas wishing to join us for public comment? I'm looking at you, Baylor. No? Seeing none. BPS, do you have anybody wishing to join us over the phone?
If you would like to provide public comment, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 346, please press star 6 to unmute yourself.
This is Marta Wilson. I am dually licensed as an MST and a CPC and a state-approved supervisor in both disciplines. I tried my hardest to get on to being able to express my opposition to SB 78. I do it now, and I agree with everything that everybody said, especially from
Thank you. I appreciate you,
individuals who came
ma'am.
from-
Just for the sake of clarity, please do submit your remarks in writing, and we will make sure that they get uploaded to Nellis so that anybody can see them. Next caller wishing to join us for public comment, please.
Chair, you have no more callers wishing to speak at this time.
Thank you. Once again, everybody, thank you for after hours, or what is it, Government Affairs After Dark. I do want to let members know that while we don't anticipate Wednesday being as long as today, we will be having a very long and lengthy committee hearing again Wednesday, and that's in the interest of us not having to be here late Friday and let everybody get home to their families. With that, I appreciate you members, all the thoughtful questions. This meeting's adjourned.